Test, test.
Madam Recording Secretary, are we ready to start the meeting?
Yes, Chair Vega, the meeting is being recorded.
Thank you. Good evening, everyone. I would like to call the March 7th, 2024 Santa Ana Police Oversight Commission special meeting to order. The time is 5:08 p.m. This meeting is taking place with in-person attendance at City Hall in room 1600. The public can also watch the meeting online via the Santa Ana YouTube channel or the city's website. Madam Recording Secretary, can you please conduct roll call?
Thank you, Chair Vega. Commissioner Castillo. Thank you, Chair Vega. Commissioner Castillo-Lawton. Noting for the record, Commissioner Castillo-Lawton is absent. Commissioner Goransky. Here. Commissioner Mejia.
Present.
Commissioner Perea. Noting for the record, Commissioner Perea is absent. Commissioner Said. Here. Vice Chair Carpenter.
Here.
Chair Vega.
Here, thank you. I will now lead us into the Pledge of Allegiance. Everybody can please stand. Right hand over your heart. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, now we're gonna move on to public comments. Now is the time for the commission to receive comments from the public on agenda and non-agenda items. Pursuant to the Brown Act, the commission may not enter into discussion at this time. Speakers will have 3 minutes for their comments. Madam Recording Secretary, is there anyone that wishes to speak in person?
Yes, Chair Vega. Bomaro Vicente, please come to the podium.
I'm gonna say if that's okay. Hello, Commission. My name is Bomaro Vicente, Boomer. I'm the Policy and Political Director for Chispa. I addressed you all last month's meeting, and I'm here once again to express my concern regarding James' training for the Commission. Last month, James blatantly disregarded AB 392, the central standard that officers must follow when using deadly force. After AB 392 was signed, statewide police lobbyists and Lexipol advocated that AB 392 didn't change the deadly use of force standard. They said that the law continues to be objectively reasonable federal standard, the standard set by Graham versus Connor. Importantly, however, AB 392's legislative history, legislative staff analysis, and the California Post Commission have all agreed that AB 392's necessary standard goes above the federal constitutional standard set by Graham. Once signed into law, the ACLU, CARE, and CHISPA collaborated with city attorneys to ensure SAPD's compliance. Santa Ana had to amend Lexipol's policy to align with AB 392. And the city sent a letter to Lexipol stating their misinterpretation of the law. I highlight this effort because local groups invested significant energy to ensure that our deadly use of force policy is consistent with state law. For an outsider like James to disregard the legal standard is a disservice to all the collective work, including the city's effort to ensure compliance, mitigate risk, and save lives. This is exactly why we express concerns about James' background and why we insist that training should be conducted by external agencies not affiliated with law enforcement and police association. I am aware that the city has been in discussions with groups like the ACLU to organize trainings on AB 392, and I urge the city to proceed with this. ACLU attorneys are available on April 16th to conduct this training and are willing to work with the commission schedule to do this. Lastly, regarding ride-alongs for the commission, I do not believe that this should be mandatory for everyone. In 2015, as part of my duties as a police commissioner for the city of Berkeley, I participated in a ride-along where I was harassed by the officer I was assigned to. This officer ridiculed my experience as a youth, bullied homeless individuals, and threatened to arrest a homeless person, and even pressured me into performing baton strikes on him. My title as a commissioner did not shield me from these experiences, and I had to blow the whistle on national radio for the city and commission to finally intervene. I highly encourage commissioners to be mindful when participating in these ride-alongs and to ensure that such experiences do not occur. Thank you.
Chair Vega, that concludes the public speakers.
Okay, thank you. So now we move on to the only item on the agenda, and that is to continue training on constitutional legal foundations for potential violations of the Constitution, legal considerations regarding use of force standards, use of force statistics, and related topics.
Chair, before we begin, could I
Sure.
indulge Mr. Touchstone with a few questions, if he's would be so indulged? Yes, sir. I have a kind of a fundamental question for you. I understand that you do not practice criminal law, correct? That's correct. You're not a public attorney or never have been one. A public defender or never have been one. No, sir. But you do know criminal attorneys and you do know public defenders, correct? Yes. Would you find those people to be partial to criminals and crime, given that the business they're in is protecting criminals?
No, I do not believe that. I think they're there to serve a role I think it was on. Oh, I'm sorry. I think they're there to serve a role to protect the Constitution and ensure that everyone's individual rights are respected, to respect the system, which requires a due process be provided to individuals before their civil rights are taken away through imprisonment and or other punishments, to protect the rights of victims who may get victimized by criminal behavior and so forth. So, no, I don't think they are advocates for one or the other. I think they're there to foster and protect a system which our founding fathers and mothers put in place.
So you in your situation, you're doing a job, correct?
Yes, sir.
And happens to be on protecting police, if you will, from criminal litigation and those types of things, correct? Just as a criminal defense attorney would protect his client from being prosecuted.
Well, in fact, I do not represent officers in the criminal prosecutorials.
My-
But from a civil rights perspective, yes, I do a job to defend those officers when they get accused of civil rights violations. As noted in my first comments, the first session, my firm and myself also takes actions to have police officers terminated if they violate people's civil rights, they violate policy for a department and so forth. So it serves the profession no good to have cops who should not be cops on the streets. And so you have to look at both sides of the coin always.
No, I appreciate that. And again, like I say, you're in the legal field and you could have chose criminal law, you could have chose divorce attorney, you could have chose civil litigation, you could have chose corporate law. You chose this path.
Yes, sir.
That does not mean you are biased towards police or are partial towards police or any of those things, correct?
No, it doesn't, sir.
Okay.
I have to look at every case as it comes before me, and sometimes mistakes are made, sometimes by both police officers and suspects, that I wish in hindsight we could change so that everyone walks away and goes home safely.
Thank you.
Do any other commissioners have comments before we resume training? I do just want to say thank you to the staff for making this special meeting happen. I think it's important that we get our training completed. So I really appreciate that. Thank you. And so, yeah, please proceed.
Are we ready to proceed? All right.
Yes.
Thanks very much, folks. So when we last ended, I was going over several slides referencing specific sections in the Santa Ana Police Department's policies, and we left off with this slide, which is a provision, it's 300.2.1, which is the duty to intercede. As you'll note, this policy provision requires a Santa Ana Police Department officer if they observe another law enforcement officer or employee using force that, beyond that which is necessary as determined by an objectively reasonable officer under the circumstances, shall, when in a position to do so, intercede to prevent the use of unreasonable force. You'll note that there is a government code section that is referenced there, 7286. This is part of SB 230, which was also enacted around the same time that AB 392 was enacted. This has also been federal law for a number of years, the duty to intercede. That has been required of law enforcement officers long before those state law enactments were made. One of the things that we also reference there is when observing force used by a law enforcement officer, each officer should take into account the possibility that the other law enforcement officers may have additional information regarding the threat posed by the subject. So what that second section is designed to do is to note that first officer on the scene may have additional knowledge that the second or third officers arriving on the scene don't have. So for example, a officer number 2 or number 3 arrives on scene and the first officer is engaged with the suspect. Let's say the suspect is face down on the ground, the officer's trying to take him into custody, and the next 2 officers see there's a lot of force going on here, and they may wonder why, like that doesn't look appropriate to us. But for example, the officer may then shout back, he's got a gun in his waistband, he's got a gun in his waistband. So while the second and third officer who arrive on scene may not have seen that actual weapon with their own 2 physical eyes, through a legal doctrine known as the collective knowledge doctrine, all 3 officers can take into account the first officer's observation when engaging with that suspect, and also when choosing which level of force to apply to ensure that that suspect is taken into custody as safely as possible for all parties concerned. So that's the duty to intercede, kind of in a nutshell. This is incorporated in Santa Ana PD's policies, and as noted, it's been the law, federal law, for over 20 years. So any questions about that specific section? All right. A couple of other provisions which I thought were important to point out that are in Santa Ana PD's policies. There's a requirement that all of its officers utilize fair and unbiased use of force in carrying out their duties, and essentially treat everybody equally based on the facts and circumstances known to the officer at the time, without regard to race, religion, ethnicity, anything of that sort. Everyone is to be treated equally based on the actions of the person that the officer is encountering at the time. In addition, there's a duty to report excessive use of force. One thing I want to go back on, actually, on the duty to intercede that we were just discussing there. Under SB 2, the decertification bill, which was enacted here in California, that is one of the 9 areas of serious misconduct that can result in an officer being decertified to be a police officer in the state of California. So for example, that an officer may not have actually used any force on a suspect at all. He may just have watched another officer utilize what is clearly beyond what was reasonably appropriate under the circumstances. And if that officer failed to do anything to intercede to stop that, and they had the ability to do so, then they would be equally as culpable under both legal theory for civil rights liability for monetary damages, as well as potentially being decertified so that they can no longer be a peace officer in the state of California. So that's something I think it's also important to point out.
I have a question.
yes,
Can you
ma'am.
define what unbiased means in here? Like, how is that defined?
How it's defined in the Santa Ana PD policies, I don't have that provision in front of me. Okay. I do have some slides coming up that I added from our last session, which discusses post standards on unbiased policing and so forth, which has definitional terms. So we'll get that before the evening is through, is my hope. So. And I'm sorry I didn't get the PowerPoint to city staff in time for them to print copies for you with those additional slides.
I just want to remind the commission, if you, when you speak, to please push the button so that way people can hear you on live stream.
Going to policy provision 300.2.3, officers at Santa Ana PD also have an obligation to report the use of excessive force that they observe by another officer.
Mr. Touchstone, if I can pause you for a second.
Yes,
Madam Recording Secretary, can you please note for the record that Commissioner Perea is present?
Yes, Chair Vega.
Sorry about that, Mr. Touchstone. Please proceed.
Yes. So if a officer, and this is consistent with both state and federal law as well, if an officer observes another officer utilizing what appears to be excessive force, they have a legal obligation and a policy obligation to report that force, which then pursuant to state law requires an internal affairs investigation into that particular use of force to determine whether or not the force was appropriate or not. Okay. And in fact, if an officer observes what appears to be excessive force and they fail to report it, they would also be subject to a separate policy violation for failing to comply with this policy provision in Santa Ana PD's policies. And same thing, we have failure to intercede there. That's just mentioned again. Another couple of policy provisions that I thought you should also be aware of is that the Santa Ana Police Department requires that officer-involved shootings and deaths are investigated in a thorough, fair, and impartial manner. And that there are multiple different, and I've added some language here in the parentheses there to what's actually in the policy, just so you're aware of that. That's, those are my additions to that.
I have a question. I'm sorry.
Yes.
If I can go back to failure to intercede.
Yes.
Typically, can a citizen, a resident, make that complaint if they see? Would that complaint be? How is that brought forth? Is it by another police officer who notices another police officer not interceding, or can a regular resident say, "Hey, that was excessive use of force, and there were 3 cops not doing anything about it"? How is that complaint made?
Both. So you have an internal complaint by an officer who observes that behavior and is required to report it, or alternatively, if a person on the street observes that same behavior that they believe is excessive force based on the totality of the circumstances, they can also report that. The department has a claim intake form, a complaint intake form, as well as a procedure. When they receive that complaint, they're obligated under state law to investigate it and make a determination as to whether or not that report is sustained, not sustained, or unfounded. Sustained means there was a policy violation, i.e. there was excessive force. And in your example that you provided, if the other officers are just standing there watching the excessive force going on, it would also be a complaint against them for failure to intercede. The department would also investigate that. That would entail questions of, well, you saw this, why didn't you do anything about it? Or, you know, and then the officers would answer however they're going to answer those types of questions. And then ultimately the department would make a determination on that as well.
If the complaint turns out to be ruled in the favor of the police officer, it was determined that they were the use of force they were using was correct.
Yes.
The police officer who made the complaint, is there anything? There's no retaliation, no discipline for that police officer who maybe thought there was a use over excessive use of force?
No, there definitely is not. And if there were any type of retaliation for reporting a potential use of force, then that would provide that officer with another basis for a lawsuit, actually.
Thank you.
So, yeah, that's the whole purpose of the investigation, is to make that determination. And, you know, different people can look at things different ways. As noted in the previous couple of slides when we were talking about the duty to intervene, maybe that first officer, that the second officer observed utilizing force that they thought was excessive under the circumstances, didn't have the full, complete picture of knowledge that the first officer had, which may be mitigating in the determination of whether or not that was excessive force or not.
Thank you.
Okay? Yes, sir.
Real quick, I have a quick question on that failure to intercede. Let's use your example where the gun in the waistband. Do the other officers have an obligation to help restrain that person to kind of mitigate some of that excessive force, for lack of a better term?
Restrain the officer?
No, the individual. Shouldn't they have an obligation to jump in?
Oh, yeah. Okay. So they're going to jump in, but I will also, there's a second side to that coin. If an officer, let me give you another hypothetical to illustrate this. Let's assume that a suspect is handcuffed, they are non-resistive, and the first officer, for whatever reason, or a second officer, or third officer for that matter, in our 3-officer scenario, becomes upset at that person and starts punching them for no reason. Then the other officers who are on scene and have the ability to do so are required to intercede, i.e. grab his arm, pull that officer away, and so forth. There would then be a couple of, getting to my other slide here, 305.3, there would be multiple investigations in that hypothetical. Number one, the policy violation for use of excessive force. Number two, you're looking at a potential criminal investigation as well, because that would be a battery. If that is not called for, if the suspect is not resisting, then an officer punching that handcuffed suspect in the face, or any other portion of their body for that matter, that would constitute a battery, which is not legally justified, and that officer would be held to the same standard as if you were to come up and punch me in the face for no good reason. There is also, so investigations would take place with Santa Ana PD, the Orange County District Attorney's Office. Those are those little acronyms that I have there in the side that I added. A criminal investigation of the involved officers' actions, OCDA and the Attorney General's Office for the state, as well as potentially the U.S. Department of Justice for utilizing excessive force under color of authority. So those are investigations that would also potentially take place. Next one down, administrative investigation as to policy compliance by the involved officers. That's typically the Police Department's Internal Affairs Division or Professional Standards Bureau, whatever it is designated here. And then ultimately civil investigation to determine potential civil liability, typically conducted by the City Attorney's Office. So there are multiple levels of oversight and investigations that take place in those types of scenarios, if that answers your question. Yes, ma'am.
Yes, it does. Thank you.
Just push the button and the light will turn on.
Thank you. Why do I always get that mixed up? Always pushing buttons. This might be a silly question, but this always reminds me of the Rodney King situation. Is there a certain amount of officers that are allowed to, let's say, pounce on a victim, not a victim, on a person that's committed a crime, such as the Rodney King deal? I remember back then there were about 13 officers on top of that guy, which was ridiculous. And since then, over the last several years, I forget which another one took place, and there were way too many officers. It's just like they just take a dive. Is there a certain amount of officers that are allowed or that they require to take over and, you know, put that person on the ground and tie him up or handcuff him and take him away?
No, there's no specific number, although, you know, you have to kind of look at the situation. So, for example, if you have a 6'5" bodybuilder, large muscle mass, and is able to fight off a number of officers, then typically that would require additional officers to try to take that person into custody, and or potentially the use of a taser or other what are known as intermediate levels of force, pepper spray, batons, etc. So and in addition, what you sometimes see is too many officers becoming involved, which then becomes somewhat of a tactical nightmare where they're actually interfering with each other in taking a person into custody because they're crowding each other. The whole purpose is to get somebody into custody, i.e. handcuffs. That being said, it really varies based on the circumstances that the officers have in front of them. The opposite extreme, let's say you have a 120-pound individual who's not very physically strong. Typically, you would not see more than two officers in that situation, maybe three. There might be one to control each arm, and then perhaps if that person is kicking, another officer controlling the legs. Again, you have to look at everything kind of with a fresh eye, shall I say, if that makes sense.
What about the method that happened in Minnesota of the foot on the neck? I mean, that was absolutely ridiculous to watch that for so long and watch the poor guy die right in front of everybody. Is that a maneuver that they can use, that they were allowed to use? And do we have that? And if we do, why?
California policing
Don't have
has
that.
not permitted that.
That's good, okay.
Does not, has not for, I don't even know how many years.
Okay.
The answer is no. Now, does a hand get placed on the neck temporarily when they're trying to hold somebody down, their head? Yes, usually as the hands shift, if someone is struggling, I've seen that occur, but it's usually very temporary, and it's in an effort to control the upper body. Typically, you're having hands on shoulders, upper back area to the sides, the shoulder blade area, and perhaps a hand on the head holding it down in certain circumstances, again, depending on what the officers have in front of them. You may also have partial body weight placed on a person, typically on their lower back, buttocks area, their legs, their shoulder area, shoulder blade area. Officers are generally very careful to keep body weight of any significance off of middle person, somebody's torso. Again, it's not, when that is being done, many times the suspect is resisting, so the body is shifting and moving constantly, which has to be taken into account. But you want to look at all of those circumstances. If the person is non-resistive, no. You really, you shouldn't have any body weight at all. That's usually applied to take somebody into custody. If they're not resisting after that, then they're going to be either stood up, taken to the patrol car, sat up, put in a side recovery position, typically the left side. There's a variety of things that can occur depending on what's happening, if there the resources available and the total circumstances.
Okay, thank you.
So, yes.
I have
Yes,
a
ma'am.
question, since we're still in the subject of use of force.
Yes.
So in the last training, you mentioned that necessary has always been used in language. And I'm curious as to if you can explain, if that is the case, then what does AB 392 actually do if that was the assumption, right? That adding that, so what does it actually do?
Well, AB 392 updated a very old California statute. I think it was adopted in 1872 concerning justifiable use of force by police officers, which was far overdue. Frankly, that was unconstitutional. It was far outdated and not up to current standards of Graham versus Connor, Tennessee v. Garner, even for that matter. So that definitely needed to be updated. What it also did is it added, and I have a copy of 835A of the Penal Code here. I'm happy to share with you if you'd like. It also added a fact that officers are not permitted to utilize deadly force against someone who is only threatening themselves. It explicitly stated that. It kind of seems self-evident, but as I think I noted before, there is a very quick distinction between somebody, let's assume they have a firearm in their hand. I'm going to kill myself, I'm going to kill myself, I'm going to kill myself. An officer would not be justified in shooting that person if they're only threatening themselves. From this to this is very quick, though. So threat to themselves only, now threat to you as the officer. So at that point in time, when an officer perceives that, they would be justified because you now have an imminent threat of serious bodily injury and or death to that officer in utilizing deadly force to protect themselves, their fellow officers, and other citizens standing around. So 392 also put that explicitly into California state law, as well as updating, I think it was Penal Code Section 196, it updated. And it added some other provisions. It also went, in my opinion, a little bit above Tennessee v. Garner. Tennessee v. Garner is the case, kind of a seminal case. It was changed the state of the law when it came to shooting fleeing felons. Many years ago, common law, you could shoot any fleeing felon, whether or not they posed a danger to any other person at all. And the court in Tennessee v. Garner said that's not reasonable under the Constitution. So it changed that and stated only if that person committed a a felony which resulted in serious bodily injury or death or threatened serious bodily injury and or death. So AB 392 took Garner and they added a little bit more to it, and they said essentially, if you have reasonable cause to believe, and I'll read the verbiage to you here, to apprehend a fleeing person for any felony that threatened or resulted in death or serious bodily injury if the officer reasonably believes that the person will cause death or serious bodily injury to another unless immediately apprehended. Where feasible, a peace officer shall, prior to the use of force, make reasonable efforts to identify themselves as a peace officer and to warn that deadly force may be used unless the officer has objectively reasonable grounds to believe that the person is aware of those facts already, i.e. if they're in full police uniform and so forth. Hey, I'm a cop, is kind of superfluous under those types of circumstances. They can clearly see them and so forth. So it added that probable cause to believe that if someone is permitted to leave, that they may inflict harm on others. So an example I'll give you to kind of illustrate what I think is a little Tennessee v. Garner plus. Tennessee v. Garner kind of looked only backwards, but 835A looks forward as well. Not only do you have to have a felony which threatened or actually inflicted serious bodily injury and or death, but you also have to have reasonable cause, I say probable cause, to believe that unless they're immediately apprehended, they're going to be able to inflict that on somebody else as well. So you have, let's say you have SAPD officers who are chasing an individual and they know that that person is running into a field that extends for 5 miles. There are no homes there, there are no people. They have a helicopter in the air with FLIR, which detects body heat, demonstrates there are no other human beings in that field. So just because that person committed a felony that either threatened or they actually inflicted serious bodily injury and/or death, they would not be justified in simply shooting that person in the back as they ran away. Now let me vary that scenario a little bit. Let's assume that that same person is running towards a school. They just shot somebody in a home burglary. Now they're running towards a school. School children are out in that schoolyard playing. That person is running over there with a knife or a gun and is getting closer and closer to those children. In that instance, the best predictor of future behavior is past behavior. And if that person is going towards their children, then that threat, that imminent threat of serious bodily injury and/or death to another person, i.e. those children playing in that schoolyard, comes to the forefront. And I would argue in that type of a circumstance, and then based on everything else that the officers may know at the time, it would possibly be permissible to shoot that person to prevent them from reaching those children and potentially harming them, taking them hostage, killing them, whatever the case may be, if that helps.
Yeah, I read the bill. I think my question was more because last time, and I just want to make sure that I have full clarity, was that there was this distinction between reasonable and necessary, which we disagreed on. But I'm just curious that if they mean the same, then what was the point of adding that word into the bill? Especially given that you had mentioned you had written, right, like, or played a role.
I did have some input on the bill, I think, in my capacity. Look, I can't go into details, because that would violate the rules of ethics in representing my clients. What I can tell you is, as part of my role as general counsel for several law enforcement agencies, I am sometimes asked to review, write, revise, make recommendations concerning legislation that's proposed and out there and so forth. So I've done that on a number of occasions over the years. SB 230, for example, I was part of drafting that and so forth. That being said, there's a variety of people who contribute to bills typically. It's not just, I didn't sit down and write the whole thing. I don't want to mislead you.
I know, I worked in Sacramento, I understand
You
how that
know the
works.
process,
That
but
wasn't my
probably better than
question.
me.
Yeah, I was more of, I guess, my question is, adding the word, does that actually change something in practice? Adding necessary on the bill, did it change something in practice? Because you had mentioned that necessary has always been there. That wasn't the case, and I guess I was trying to figure out, what am I missing from my own research that it's not matching up?
Well, so I actually went back and looked at that after our last meeting. As noted then, I always equated the two. And so what rules my world is case law. I know you can make a semantics argument that necessary may be looked at as a heightened standard over reasonable. I have not seen any case that says that. And I went back and looked at it again after you and I spoke on it, because I wanted to make sure I wasn't missing anything, because frankly, I follow the case law pretty closely. I did find one case, if you're interested, you seem to be interested in the issue, so I'll just reference this citation for you so you can take a look at it for yourself. It is the Kousara case, Koussaya versus City of Stockton, 54 Cal App 5th, 909. And that discusses the amended Penal Code Section 835A. That was a case, and again, I'll let you read it for yourself. They referenced the specific language. They ultimately found that the peace officers in that situation were justified in the use of deadly force, and that a claim for negligence by a hostage who jumped out of a moving vehicle as the officer was shooting at the vehicle, because the people in the vehicle who had just committed several robberies and so forth were shooting at them, that they had no claim under civil law, that the officer's actions were justified. That's the closest and most recent case that I could find discussing the new amended 835A. But like I said, I'm always open to learning something else. If you have a case citation for me, I'm happy to go read it. I've not read a case yet which defines reasonable and necessary as distinct, as having differential meanings. But like I said, if you have one, I'm happy to look at it. Yes, ma'am.
Is Santa Ana Police Department's MOU with the Orange County District Attorney for officer-involved shootings?
I believe there's a countywide protocol that was put into place. I don't know if it's named a MOU, it may be. What it, as I understand it, and I would actually defer to these gentlemen in uniform here, they may know the protocol better than I do. But as I understand it, and this is not uncommon, there are many times MOUs between the local county district attorney's office, and all law enforcement agencies in that particular county, which involves the district attorney's office as being part of an investigation into any officer-involved shooting. I believe that's the case here in Orange County.
And then just a quick question on the officer-involved shootings and deaths. Is that in custody deaths or deaths that happen shortly after someone's released?
Pursuant to the MOU,
Yes, or.
I don't know the answer to that question.
Okay.
I don't know what it covers. So typically, if there's an in-custody death, if someone is in the Santa Ana City Jail, then there would be an investigation into it. Certainly, if there's a shooting death, there would also be an investigation into that as well. If they're released from custody, your question is, would there also be an investigation there? I don't know the answer. I mean, I would think that it would depend in part on timing. If they die on the jail steps, maybe a different answer than if they die 2 weeks later for whatever reason. Usually there's a death investigation, certainly if there's any hint of foul play or something like that by the coroner's office at a minimum under the sheriff's office. So.
Thank you.
All right. Any other questions? All right.
Yeah, go ahead.
Yes, sir.
Thank you, Mr. Touchstone. This is not a question for you, but more a comment for the city attorney's office. I mean, it seems that there's different legal interpretations around reasonable versus necessary that we're probably going to have for many different individuals. So if we do end up having another entity that comes and does a presentation or training to the commission, it will be very helpful for the commission to hear their thoughts as well on this legal interpretation, just so we have a good variety of understanding for us. That will be helpful, especially since it seems that there's different interpretations to this.
No, I agree with you. I mean, it can be interpreted multiple different ways. What I'm looking for, what rules my world, and what I'm trying to discuss with you folks right now is what case law has said. It's not what Jim Touchstone has said. My opinion means absolutely nothing. I don't have a black robe on. What I try to do, that's why we call it practicing law, is I'll read a case and I say, I think this means that. Someone else may read the case and they may think it means something different. There's room for disagreement. I fully concede that. And ultimately what I'm looking for, though, is a court of appeal decision which gives me guidance. Then if it settles the issue, that's very different. Then what I think that means nothing, because a court of law has settled it. And that is what you should be basing your decisions on, is what the law is, which is why I'm trying to provide you with citations to everything I'm showing you folks. Don't take my word for it. Go and look this stuff up yourself. There's FindLaw, there's Google. You can type in the case citations that I'm giving you. The Santa Ana Police Department manual is up online. If there's any provisions you want, I did a lot of cutting and pasting, put together what I'm presenting to you. But again, don't take my word for it. Go look at the sources themselves. And we may come to reasonable disagreements about some meanings of things. I concede that.
Yeah, and I understand. I'm very familiar with, how cases can set precedent. But also, cases can also be reversed if another court says otherwise. So I think it's just helpful for the commission just to have a different opinion if there is out there one.
Sure.
Yes, if I just may jump in
Yes,
really
please.
quick, Mr. Touchstone. Thank you, Commissioner Perea. I appreciate it. We, here at the city attorney's office, the entire city of Santa Ana, we take this very seriously. We are trying to put together a very comprehensive and holistic training program that brings together various subject matter experts and that can provide training and education. At the end of the day, ultimately these decisions are going to be left up to you, the 7 of you. I know we're missing one, but the 7 of you will be making decisions and you will be interpreting the law in your own way, and you will be using your discretion to make decisions. And so I am in communications right now with the staff attorney from the ACLU. I am in communications with NACOL. We have finalized the agreement, so that will be coming up, so stay tuned. Our own police department will be providing training as well. So I am attempting to bring together, again, a very holistic approach to what you will learn. But again, ultimately, it will be up to the 7 of you to decide and make decisions, and it is a matter of interpretation. So I do appreciate, Commissioner, you bringing that forward, and just know, please know that we are trying to make this a very robust discussion that leaves the ultimate fact-finding in your capable hands. So I just want to leave with that.
Thank you, appreciate it.
Yeah, ultimately, obviously, you have cases come before you, it's subject to your judgment. But to your point, which I think is a great one, you may have a Court of Appeal decision over here that says this, and you have another contrary Court of Appeal decision that says this, and that may ripen that dispute in the law up to the California Supreme Court or the United States Supreme Court or whatever the case may be, which is why I kind of talked about how that hierarchy works when we first met. Frankly, it puts you in a difficult position. Which one is better reasoned? What do I think makes sense? So forth, until ultimately a high court decides the issue definitively. And I say definitively very loosely because even when you get a high court decision, sometimes that's subject to interpretation and so forth. But all that being said, yes, bring everything to the table, your own human experiences and so forth when you're judging these cases.
Hi, me again.
Yes, ma'am.
To listen to what you were just saying there, when a case comes to the end, okay, or ready to solve it, are we going to be allowed to talk with each other like in a round table, like a jury does, and discuss each other's facts or findings or something like that? Or is it just going to say, this is what I believe, that's what he believes, that's what he believes, and throw them in a pile and see how they come out?
I'll defer to Jonathan on that issue as far as your workings.
The best answer to that question, Commissioner, is it depends. It depends on the subject matter of what it is that you are tasked with deciding. Say if it's a matter of policy or procedure, it would occur in open session, very much like we're having right now. If it were a matter of misconduct that involved a specific officer, the ordinance is very clear that any discussions regarding specific officers and allegations of misconduct would have to occur in closed session. With the independent oversight director. And again, also I say this, that those discussions would also be subject to POBAR or other applicable laws that govern the release of specific documents or information pertaining to active investigations with law enforcement officers. So the best I can say is it depends. If we're talking about policy, procedures, other things that are public, that are part of the public domain, that the 7 of you are tasked with deciding or providing recommendations on, we can have that in open session. But if it is with regard to specific officers, it would be a closed session discussion. They would be confidential. And again, even those discussions would be subject to any applicable laws regarding the release of confidential information.
Okay, thank you.
I have a question that ties in with that. Are we looking for consensus here? Are we looking for simple majority on these issues that we will decide? Or is it just our recommendation that goes to the council?
My understanding, Commissioner, or I should say Vice Chair Carpenter, I apologize, is that this is a body that is advisory and makes recommendations. Those recommendations have a few paths that they can take. They can either go to the city manager, they can go to the chief of police, or they could go to the city council. And how you twist and turn and wind through those paths is all based in the ordinance. I encourage all of you to read the ordinance if you haven't already. I'm sure you have, but it's always good to reread it. I find myself rereading the ordinance every couple of weeks. It's not terribly long, but it really does a good job setting forth what this body is here to do and the recommendations and advice it is tasked to perform. So did that answer your question?
It does, but I did read the ordinance, and forgive me if I'm mistaken, but I don't think it outlined if it had to be 7 agreement, or there can be dissenting opinions in there, or how that was going to go. We're not looking for a consensus, correct? Let's say 4 of us think X should happen and 3 think B should happen. Do those recommendations go then, as they're set, to police chief, council, city attorney?
My understanding of the ordinance is that your consensus or your majority vote, if you will, would be transmitted and conveyed to the independent oversight director based on the investigation and the evidence that was accumulated by the IOD, the independent oversight director. At that point in time, he or she would prepare a report, and that report and its recommendations would make its way through the appropriate channels. Again, city manager, police chief, ultimately, potentially, the city council. And that's where it would lie.
Again, though, if we do not have consensus, and I'm not trying to be difficult here, do those dissenting opinions, for lack of a better term, do those get carried along also, or is that just the majority rule and end of story?
I think the best answer to that question is I'm not sure. I don't know that the ordinance speaks necessarily to dissenting opinions. It speaks to this idea of the independent oversight director preparing a report based on findings and factual analysis for which he or she would present to this body, and the body would analyze it, make a determination, and my reading of the ordinance and my understanding of just the way that parliamentary bodies would operate is that there would be a vote in terms of what recommendations are we going to make to the police chief, to the city manager, or to city council based on the report that has been presented to us. And so in that sense, if you had 4 commissioners who said the recommendations is, let's recommend to the police chief that we change this policy, and 3 of the commissioners say, no, let's not do it, the recommendation would be to the police chief, we should change this policy, and this is the way that the policy should read. And it's kind of like that.
And that makes perfect sense, because if it wasn't that way, then what's stopping us from just individually going to the police department and making our own recommendation and just bypassing this whole thing?
Correct. Yes, Chair, that is correct.
Just to follow up with Commissioner Carpenter mentioned, and seeing that the director will be writing, the report in terms of what decision made, I'm wondering if then there's room there, or if this is something that the commission is to make a decision on, or the city council, whatever that is, but if there is room for the director to include in that report, kind of like maybe some of the dissenting voice, some of the, some of the comments of the folks that did not agree with that. Just kind of wondering what that will look like.
Sure, I think that that's an excellent idea. I can tell you, Commissioner, that is not addressed in the ordinance, and I would leave that to the discretion of the independent oversight director, to the extent that he or she could include it or not include it would be within their purview, and it would be something that this body would address and discuss with the IOD. But it is not permitted, or excuse me, it is not prohibited by the ordinance itself. Just know that.
All right. Good. Okay. Next slide up there is, these are just, I'm not going to go through all of these with you, but I did just want to note some of the key policies that, for reference, things that are likely to come before your purview in some of the cases that may be presented to you, these various policy provisions governing various types of use of force, vehicle pursuits, search and seizure issues, hate crimes, bias-based policing, et cetera. So those are some of the things I want to talk about. Switching gears here, some relevant statistics. And again, these are all something you can find via Google. I think that there tends to be a little bit of a misperception, in my opinion, concerning the actual use of force that results from police encounters. I think that the mainstream news media, all news media, tends to focus on very negative events sometimes. But if you look at the actual statistics, and I cite where I get these from, U.S. Department of Justice, Bureau of Justice Statistics, they do studies every year where they throughout the nation. This is, again, U.S. Department of Justice, not just California. They look at police contacts and how many of those actually result in the use of force. In 2020, which was the latest statistics that I could find, there were 53,836,600 contacts with law enforcement officers in the country. Of those contacts, 1,045,600 resulted in non-fatal threats or uses of force. This represents 1.9% of contacts. And definitionally, that includes contacts wherein officers didn't actually touch a person. They didn't utilize force, but they may have threatened to use force. Handcuffing, pushed or grabbed, hit or kicked, used chemical spray or pepper spray, used an electric shock weapon, more commonly known as a taser, pointed or fired a gun, or used another type of physical force. Definitionally, that's what that 1.9% results in. So if you look at that definition, you pare it down, significantly fewer people may have perhaps actually been touched physically by an officer, because this includes threatened with force as well. Now, winnowing those statistics down to California, again, the California Department of Justice publishes similar statistics. A little more updated ones were available that I could locate online. In 2022, there were 597 incidents that involved the use of force resulting in serious bodily injury and/or death of a civilian or officer, or the discharge of a firearm, whether or not it actually struck somebody. Of those incidents, 74.9%, 447, resulted in an arrest, i.e. someone ultimately was accused of breaking the law. There were 159 instances of a firearm discharged at an officer, and there were 250 instances of a discharge of a firearm at a suspect. These statistics are also broken down by individual departments, counties, in various manners. And I thought for your interest, you might want to know that only one of these 597 of serious uses of force involved Santa Ana PD in 2022, which is a very good statistic. Okay. Now, we've been talking about use of force, which is deemed a seizure under the Fourth Amendment. Obviously, the Fourth Amendment also controls searches. That's also a key component of it. And you may have in front of you some allegations that someone inappropriately searched them, their vehicle, their home, their person, etc. So I thought that it would be prudent to kind of go over some of these provisions with you as well. Okay. Clearly, we have the Fourth Amendment to the United States Constitution. The right to the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That's the verbiage of it. Article 1, Section 13 of the California Constitution contains almost verbatim the same language to that. So you have both a federal as well as a constitutional right under California Constitution to discuss that. Now, POST, which I mentioned to you, is the organization which set forth standards for all law enforcement officers throughout the state of California for training when they go through a police academy. It has a learning domain which is designated and addresses search issues. That's learning domain 16. Again, these are available online if you want to search for it and read it. I think there are 43, 44 total learning domains discussing a variety of issues. We've been talking about learning domain 20, which governs the use of force. Learning domain 16 governs search issues. And again, I'm not going to go through the whole thing with you. I think it's like 100 pages long, but I'm going to pull out some of the key provisions for you. Search occurs when an expectation of privacy that society is prepared to consider reasonable is infringed upon by the government. A seizure of property occurs where there is some meaningful interference with an individual's possessory interest in that property by the government. Again, definitionally set forth in learning domain 16. Now, let's break that down a little bit because, again, I think there's sometimes misconceptions. And we'll go into some of those details later, but people, you often hear on TV and so forth, show me a warrant. You don't have a warrant, you can't come into my house. Well, there are exceptions to the warrant requirement under the Fourth Amendment. So a police officer doesn't necessarily need a warrant, depending on the facts and circumstances, to enter your home, search your vehicle, search your person, et cetera. A reasonable expectation of privacy can exist almost any time in any place, as long as, number one, the person subjectively expects privacy in an object or an area, and two, their expectation is one which society is prepared to recognize as legitimate. So there are two components to that, both a subjective component as well as an objective component. And what does that mean in practice? Subjective expectation of privacy. I'm sorry, I'm not advancing the slides here as I'm talking here. There we go. Again, definitionally set forth in Learning Domain 16. Subjective expectation of privacy is a person's state of mind demonstrated by affirmative action designed to protect their privacy. Some examples which are included: building a fence, closing window shades so someone can't see in your home, locking a compartment in a vehicle, for example, putting something in the trunk versus in the passenger compartment of a vehicle, etc. Objective reasonableness refers to whether society is prepared to recognize the individual's expectation as reasonable. So while you may have a subjective belief and desire to have privacy in a certain situation, there's the second component of, do we consider that objectively reasonable, which is society as a whole prepared to accept it. Curtilage, that's a term you may have heard before. It's essentially the area around your house, relatively small and usually well-defined area immediately around a residence to which an occupant has a reasonable expectation of privacy. And folks, there is a plethora of case law on these issues. I'm oversimplifying it for you for the sake of time, as well as just an introduction for you on this. But there are probably 100, 200, several thousand cases discussing what curtilage means and whether or not it's appropriate, whether how high the fence is, if it's locked, if the mailman can access it. These are all factors which kind of come into play as to whether or not someone has a reasonable expectation of privacy under the case law in the area around their home. So I am oversimplifying it for purposes of this discussion. Standing. This is an issue. Doesn't mean standing up from your chairs. It means whether or not someone has a legally cognizable interest that they can prosecute. So that only exists if a subject has a reasonable expectation of privacy in the place or thing that is searched or seized. To challenge a particular search or seizure, a person must have a reasonable expectation of privacy in the place or thing that was searched or seized. Only a person with such standing can challenge the search or the seizure of property based on Fourth Amendment. And how is that usually established? I mean, standing is a very amorphous, somewhat vague term. Again, there are thousands of cases discussing that. Standing is generally established by, number one, ownership, number two, lawful possession, number three, authority over a particular area or item, and number three, control of the area searched or property seized. So let me give you kind of a common example to discuss that. Let's say that you have a home and you have roommates in that home. They have they're leasing a room from you, and they have the ability to lock their door so you can't go into their bedroom. You share the common area of the kitchen. So the owner of the home, you may have the ability to say, "Come in, Mr. Police Officer, you may search my home." However, if your roommate who rents the room and who has locked their bedroom door, that person who owns the home cannot give permission for you to search that room, because that person has a separate and distinct privacy interest in their own room. The person who owns a home can let you search everything else, which that person has no right to exclude someone from, if that makes sense, illustrating the issue. Do you have a question, ma'am? Oh, okay. No worries. No worries.
What if there was because I used to have renters back in the day, and we would have a contract that would state that if I have a reasonable reason for going into their room, and they signed off to say that I can't do that, does that override that rule?
You
that
as
you
a private individual?
Yeah, like let's say I had a renter and I said, look, if I feel like there's something going on in your room, then I have the right to go in and inspect, and they agree to that. Would that go into play in this scenario?
No, that's separate and apart from the Fourth Amendment entirely.
Okay.
Again, to kind of conceptualize it, the Fourth Amendment restrains actions by the government. So that's a private party issue, maybe breach of contract. You may argue privacy interests that they may invade. That's separate and apart from the Fourth Amendment, because you're not a governmental actor acting under color of authority.
Thank you.
Again, probable cause, the term that gets thrown around a little bit. Well, what does that mean? Probable cause to search an area or object means having enough facts or information to provide a fair probability or a substantial chance that the item sought is located in the place to be searched. So, for example, when officers issue search warrants, they have to develop an affidavit to support the request for a search warrant from a judge, and they have to set forth a variety of information, what they're looking for, why they're looking for it, why they think that it is either evidence of a crime and or is contraband, and why they think it's likely to be found at a particular location and so forth. So all those things have to be set forth. Ultimately, probable cause, if there is enough facts and indicia of the things that they're talking about here, is there, then the judge will issue the search warrant, or he or she may say, no, you don't have enough, you need to address this, you should come back to me later on. So that's how that works. Because again, going back to the Fourth Amendment, you only get a search warrant if you have probable cause to support it. Okay?
If you have probable cause to search a home, and let's say that that's due because maybe somebody's son did something right, but the mother is the one that's home, she's not aware of anything that's going on, are the police required to let the mom know why they're in there, why they're doing what they're doing?
Well, that could go a bunch of different directions. If they have a search warrant, they're required to present the warrant, knock, announce who they are, give the person an opportunity to allow them in, which I'll address in a couple of slides here. Do they have to say exactly why they're there? No, is the short answer to it. That being said, in my experience, many times officers will explain why they're there, particularly under the circumstances that you outlined there. They're looking for a son, and the mother answers the door, ma'am, I have a search warrant, we need to search your house, we're looking for Tom, or we're looking for Jim, or we need to search Jim's room, we believe he has drugs in there, or weapons, whatever the case may be. But again, the search warrant outlines the scope of the search. And I don't want to get too far ahead of myself because I do address some of those issues. But practically speaking, a lot of times that information will be provided. Is there a legal obligation to do so? No. Probable cause requires something less than absolute or even near certainty, but something more than mere hunch or suspicion. In other words, it has to be based on some indicia, some observations, some factual information that an officer may have observed or may have been reported by other individuals, etc. I'm guilty as charged on this. I keep forgetting. I'm flipping my pages, but here we go. Peace officers must demonstrate their probable cause exists to search a specific place for a specific property or contraband, which will be used as evidence. Even though the court will consider the totality of the circumstances to meet that Fourth Amendment requirement, officers must have specific facts which can be articulated in court or in a sworn affidavit. That's what I was talking about. It's typically called a probable cause statement or an affidavit in support of, with respect to specifically search warrants, affidavit in support of the application for the search warrant. To establish probable cause, peace officers must be able to articulate how and why they have a fair probability to believe. Number one, a crime has occurred or is about to occur. Evidence pertaining to the crime exists. The evidence is in the location they wish to search. That all is set forth in the affidavit. And again, those affidavits will vary in length, in scope, in everything that goes into them just based on the underlying crime at issue and so forth. So, unless justified by an exception, and there are many exceptions, consent, incident to arrest, search condition, or an emergency, aka exigent circumstances, a search of private property may lawfully be conducted only if authorized by a search warrant. And again, what is a warrant? We hear that all the time, you know, while you watch Law and Order on TV and so forth. A warrant is an order in writing in the name of the people signed by a magistrate, a judge, directed to a peace officer, commanding the officer to search for an individual or individuals, things, a thing or things, or personal property. In the case of a thing or things or personal property, to bring the same before the magistrate. So they have to go search. If they find anything, they seize that evidence, and then they have what's called a return, and I'll get to that in a little bit too, as far as some of the nuts and bolts of this stuff. Again, what peace officers must articulate, probable cause, something has been committed, a crime has been committed, and we think evidence is there and the identity of the person located at the place to be searched. Arrest warrants, slightly different, must articulate the probable cause that a crime has been committed, that the individual to be arrested committed that crime. Again, probable cause, not absolute certainty. That's what trials are for, is to determine beyond a reasonable doubt whether someone actually violated the law.
I have a question.
Yes.
Well, so what happens when it's a traffic violation? So for example, if somebody ran a red light, is that a probable cause to initiate something that might escalate into something else?
So if somebody runs a red light, they've committed a traffic violation.
Correct, right. Mm-hmm.
Generally speaking, infraction. There may be other circumstances. I don't know if a red light violation would ever rise to the level of a misdemeanor. Speeding can, if you exceed certain speeds, it can be a misdemeanor violation. So typically what is done is you're provided with a notice to appear, and you sign it, which is saying you're not saying you're guilty, but you are going to appear at court. And here in California, we have a procedure. You don't even actually go to court. Most of the time, it's by written affidavit if you want to contest.
Yeah, sorry, I wasn't clear. Sorry, it's been a long day. My question was more, if you run a red light and then the law officer pursues you and that escalates into abuse of force, is that reasonable because you ran a red light? Because I've heard of these situations, right, where scenarios where somebody's runs a red light, they're followed, and that escalates into something else, and then there's a use of force. Is that?
That is a question that is very broad. That would depend on the actual circumstances
Okay.
Of the particular situation. So typically, if someone runs a red light, they yield if the officer activates lights and sirens. They would yield, pull over to the side, they'd be written a citation, they'd be free to go if they signed the notice to appear. Okay, that's typically what would happen. Now, that being said, let's say an officer pulls over somebody who happens to be a very bad person. The officer walks up to the door and that person's got a firearm. They start pointing at the officer. That could escalate very quickly to use of deadly force. So there's a variety, everything in between could occur as well. They may flee, then you have a pursuit situation, may use spike strips to stop them. A variety of things could occur. So I don't know that I can give you one answer to that.
Yeah, I guess. So let's say somebody runs a red light, the police officer has a reason to stop them, and then the person doesn't yield.
Okay.
They're not carrying any gun. They have no harm. They're not drugs. They're not on any illegal substance, no alcohol, but they still did not yield for whatever reason.
Okay.
Then that can escalate, and let's say then the officer does use of force to stop the vehicle. Is that still justified?
That is a very broad hypothetical. It would
Okay.
depend on a variety. I can't give you one single answer to something like that. So, there's something called a pit maneuver, pursuit intervention tactic. You see on TV a lot. If someone is engaged in a pursuit and they're acting in a dangerous manner, the officer may initiate a pit maneuver to stop the pursuit because that person is potentially going to harm people. They're running red lights, running stop signs, things of that, high rate of speed, driving on the wrong side of the road. There's a variety of things that could occur. Generally speaking, look, totality of the circumstances means the beginning of the story to the end of the story. So you would look at number one, does the officer have reasonable suspicion to believe that a crime has potentially occurred? Or in this case, in what you've talked about, a traffic violation. That would justify that officer in attempting to pull them over, writing them the citation for the violation. If they speed off, now we're talking about something else. I think it's Vehicle Code Section 2800.1 or 2. Again, I'll defer to the gentleman in blue on that. But that's just out of memory. That can progress into misdemeanor behavior if they're fleeing, failing to yield. Could progress into felony if they are endangering the lives of other people. And there's no good one answer to that, what you're asking me. Going back to this, so you have, again, just some definitional stuff, and I don't want to spend too much time on this. This is stuff that...
I think I'm going to recess. It's been an hour and 15 minutes, so
Sure.
I'm going to go ahead and recess for 10 minutes, and then we're going to return.
Sounds good.
Thank you. Madam Recording Secretary, we can please start.
Yes, Chair Vega.
Okay, this meeting is resumed. The time is 6:26, and we are continuing with the item training.
Thank you, Mr. Chair. These are some terms that are identified and defined for peace officers so that they can have a better understanding of the concept of probable cause. I'm not going to read through these per se. These are fairly self-explanatory, but they are for your reference in later, taking a look at some of these cases. Direct circumstantial evidence, reasonable inference that can be drawn from things. Reasonable inference, typical example that if you have small children, you have the proverbial cookie jar. You didn't actually see your child eating a cookie, but you know that there's one less cookie in the jar from what you put in there 2 hours ago, and your child has crumbs on their face. Reasonable inference that perhaps they ate one of those cookies. Maybe not necessarily, but a reasonable inference, okay? Just to kind of illustrate it. Again, under certain circumstances here, peace officers may secure a residence while in the process of obtaining a search warrant. So, for example, if there is, well, it can get somewhat complex. Let's say that an officer enters a residence under what's known as an exigency exception to the warrant. They may not necessarily conduct a full search in that residence. You're typically going in there to preserve or somebody's safety. Then they will secure the residence to ensure that evidence doesn't get destroyed. They may see, for example, they're going in, they hear screams. Outside it, there's a report from a neighbor saying, hey, there's something going on over there. I'm hearing banging, I'm hearing screams. The officers will typically go knock, hey, we need to see if everyone's okay. They may ultimately force entry if not permitted to come in. And then they get into the residence. They see someone who appears to be battered and bruised, bloody. They may also see 2 kilos of cocaine sitting over there in plain view. In a circumstance like that, what will many times occur is that the officers will take care of the person they saw. They will not touch anything, not conduct any further search, secure the residence, go and seek a search warrant, which would allow them to go in all the nooks and crannies, inside drawers and things like that, where a person couldn't be hiding, for example, but may have other indicia of crime, evidence of crimes, and so forth. So in some circumstances, that will happen. An area may be secured pending issuance of the search warrant, and again, the criteria. If the suspect has been arrested inside a location, an area may be secured pending issuance of a search warrant if companions of the suspect may destroy items sought upon learning of the arrest. So you may only arrest 1 of 5 residents, but the concern is the other 4, if permitted to stay there while you're going to seek a search warrant, may destroy evidence and so forth, and so they can take those persons out of it, secure the residence, restrain those individuals, in fact, for their own safety under certain circumstances, get the search warrant, come back, and then look through everything. Under the provisions of Penal Code 1534, which is what state law which governs the search warrant procedures here in California, search warrant shall be executed and returned within 10 days of issuance. So you go and you get the search warrant. Typically, you're given 10 days to actually go and execute the warrant, i.e. conduct the search of the home. The return of the warrant means returning the warrant and a written inventory of the property taken to the magistrate. Your Honor, you gave me permission to seek this stuff, and this is all in writing. This is not a verbal report like I'm kind of giving you an example of here right now. But they'll go search the residence. We were looking for this. Here's what we found. And so you're given that return to the magistrate issuing it. Normally, a search warrant can only be issued between the hours of 7 a.m. and 10 p.m. Normally, there are certain circumstances where that may not be the case. Prior to entering a residence and searching a dwelling with a search warrant, officers must comply with the requirements of what is known as knock and notice, set forth in Penal Code Section 1531. Knock and notice simply means that before entering a dwelling to serve a search warrant, officers must give notice to persons inside through certain actions. And again, to satisfy those, we have the next slide here. Knock or otherwise announce their presence. Police, we're here to serve a search warrant. Santa Ana Police Department, we're here to serve a search warrant. State their purpose, demand entry. Let me in right now. wait a reasonable amount of time, allow somebody to unlock the door, let them in. If necessary, forcibly enter the premises if they won't open the door. If knock and notice requirements are met, including refusal, peace officers may legally break in to force entry into premises to execute a search warrant. There are what are known as no-knock warrants, which dispense with those requirements under certain limited circumstances. And in those cases, you may get a warrant, and this has to be signed off on by a judge. The law allows peace officers to enter private property unannounced if they can demonstrate that compliance with knock and notice requirements would be futile, or that compliance could result in, number one, harm to the officers or other individuals, for example, hostages, or two, the destruction of evidence. I will tell you that in California, police departments have generally been going away from no-knock warrants. They're still legally permissible, but they're very carefully looked at from both law enforcement's perspective as well as judicial officers' perspectives, because there's sometimes could be the potential for violence that occurs. Yes, sir.
A quick question for you, just for the sake of clarity. Is a search warrant executable if nobody is home?
Yes.
And that would be a forced entry then, correct?
Yes.
Thank you, sir.
Yeah. Otherwise, bad guys simply wouldn't go home.
No, I understand. You know what I'm saying, because any one of us could have an issue warrant, a search warrant issued on it. So I'm just curious if that was the case.
Yeah, if
now,
that-
now you come home and your house has been searched, right?
Yes, exactly. And what you'll typically get left a copy of inventory of everything that was seized during that search. So number one, you know it was a police department there and you weren't burglarized. And number two, yes, we came in, we searched, and here's what we took from your residence. Okay.
I don't know if this will be addressed later, but I'll ask it now. What
Yeah.
happens if the search warrant did not produce anything? Maybe there was a mistake. Turns out that maybe, I don't know, there was something wrong and there was nothing there at the house to search. Any damage to the property, is that, does the police department or city have to pay for any damages during the search warrant?
So that depends on the circumstances as well. So, for example, peace officers are legally justified in forcing entry if they have a warrant and either someone is not home and or they are refuse entry. So you're given a order saying you can do that. If you have a situation where the wrong home has a search warrant executed on it, for example, which has occurred, then in my experience, then yes, typically the city would pay for damages to a wrong home, repair the door that was kicked in and so forth, because there was simply a mistake made, you know, and sometimes that occurs. For example, particularly if you have back units with separate addresses, there's a variety of things that could happen that could cause that to occur. Sometimes there's simply a wrong numbering on the house out in front versus this is the house, it's the gray house, and it says here, but it's actually the wrong number, either by mistake and or design sometimes. But usually if there's a mistake made like that, then yes, they will do it. They will pay for it.
Real quick question, follow-up. Again, you're not home. Let's say this is a white-collar crime, so we're not talking about drugs or guns or anything like that. Door gets broken in, there's an accounting and all that kind of stuff. Is the house left unsecured?
Usually they'll take reasonable efforts to secure the home when they leave.
Okay.
Yeah.
Thank you.
Yeah, they won't just walk out and leave the door open. Typically they'll take reasonable efforts to secure the home.
Please keep this at CP stays there and legend your house.
So let's, we've been talking about warrants, what it takes to have them issued. Some of the, again, this is, I want to emphasize, this is a very cursory level. There are libraries of books which discuss everything I'm discussing with you over this tonight's session and the prior session. But I'm trying to break it down into something that's plain language that makes sense. And I'm also focusing, as you'll note, as I've stated several times, learning domains. This is how cops are trained. This is a lot of the verbiage is how police officers are trained. So you are going to be judging the actions of peace officers, so I want you to know how they are trained so you can understand what their mindset is and then make your own judgments based on your own life experiences and knowledge, research, etc. Okay? So some exceptions to the warrant requirement that we've been talking about. There's what's known as the plain view doctrine, and this is something you may have heard before. In a constitutional sense, when an officer sees an item in what is known as plain view from a place that the officer has a lawful right to be, no search has taken place. So it's not actually even a search, as long as the officer has a legal and lawful right to be where they're standing. If they can see something in plain view, so for example, you have your car parked in a parking lot, you get out and you leave your AK-47 sitting on the passenger seat of the vehicle, and it's got what is apparently a 30-round magazine in it and so forth. And an officer walks by, looks through your untinted windows, sees that in plain view, then that is not technically a search. And so there may be issues there. The officer would probably go and get a warrant to seize the vehicle and or search the vehicle if there's nobody around, for example. There may be an exigency issue that they may actually break the window to ensure that public safety is enhanced and seize that weapon, which is something I'm trying to give you let's say it's a bazooka, something that's clearly illegal, okay? And in that sense, then they may either seize the vehicle, get a search warrant, certainly secure the vehicle so that somebody can't come back and get the bazooka and go out and, you know, blow up a football stadium and something along those lines. So in that case, the owner or possessor obviously has no reasonable expectation of privacy for those items which are in plain view. Without an expectation of privacy, the owner or possessor has no Fourth Amendment protection. Peace officers must meet certain requirements before an item in plain view may be seized legally and used as evidence. Number one, probable cause, i.e., in my example, bazooka, which is against California law to possess, that's evidence of a crime. So there's probable cause to believe that that is contraband as well. A lawful right to be in the location. You're in a public parking lot. You can walk around the car as you see fit, UI, including people who wear badges, and lawful access to the item. Again, that can kind of vary on how the officer wants to approach it. From my perspective, if in doubt, get a warrant, unless there's a clear exception to the warrant requirement. You're always safer if you have a judge signing off on a warrant to seize any particular item. Plain view is somewhat misleading in that it would typically tend to make you think that that just means seeing something. That's incorrect. That includes all of your senses, not just sight. So you can obtain potentially probable cause to conduct a further search or to go into a home by seeing something, smelling something, touching something, hearing something, etc., as long as you're in a lawful place to do so. Simply because an officer can see an item in plain view from a lawful location doesn't automatically mean that the officer may legally enter private property without a warrant to seize it, even if the object is obviously contraband or evidence of a crime. The officer also needs lawful access. Again, typically a warrant or an exception to the warrant, exigency being one of them that we're discussing here. Lawful access to private property is typically obtained through a variety of contexts. Number one, consent. Sir, I'm here, Santa Ana Police Department. I'd like to search your home. We believe X, Y, and Z may be happening here. May I search your home? Sure, come on in. You now consented. The officer can lawfully walk in your home, search your home, and so forth.
Can they take back that consent at any time?
You can also give limited consent. So you can say, you can search my living room, but not my bedrooms. So yeah, you're controlling the amount of authority that you're giving the officer.
I would think that if the officer had a warrant from the court, that it's to search the whole house, the whole property.
Yes, ma'am, that's a different scenario entirely. We're talking about exceptions to the warrant requirement.
Oh, I see, okay.
Yeah, so if someone can give you consent, they don't have a warrant and they're knocking on your door,
Gotcha.
saying, hey, I'd like to search your home. Listen, we've heard some, we smell some odors coming out of it. It smells, it's consistent with methamphetamine manufacturing. They're not gonna go into that kind of detail, but hey, we'd like to search your home. You would be let into the home if they say yes. And you've essentially relinquished your privacy rights by allowing the officer to come in.
Thank you.
I think what Chair Vega may have been asking was, is there a situation where you can give full consent to search the entire house and police officer now is making his way to, say, the master bedroom, has his hand on the doorknob, and then can can the individual then withdraw that consent and say, I want you to leave at this point in time?
I believe they can, yes. So for example, yeah, come on in, you can look around. That's kind of ambiguous. They start walking around, they're walking around the kitchen, the person's there, they start going to grab their bedroom door. Whoa, 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 can't go into my bedroom. I think a reasonably prudent officer in that, they're not gonna argue that the prior consent, say, come on in, you can look around, would then extend to the bedroom. The safer course of action would be to back out. If you have probable cause that would justify a warrant, get a warrant, go in there. Again, depending on the nature and circumstances, maybe you're securing the home, taking that person out so contraband can't be destroyed in your absence during the intervening time when you're getting the warrant. The safer course of action there would be to step out because that consent has been limited. You've now taken back what certainly was ambiguous.
And obviously, if that person says, I give you consent, they open the drawer, there's a gun, and they're like, no, I take back that consent. At that point,
Too late.
too late.
Too late, yeah. Yeah, you can't unconsent after the fruit of the crime has been discovered, so. Another common exception, the officer's entry is based on exigent circumstances. For example, a reasonable belief that evidence will be destroyed if entry is delayed in order to obtain a warrant. Or number two, the third one, which is most commonly done, the officer has lawfully entered the area for some other purpose, for example, to conduct a parole or probation search or an administrative or regulatory search. So the lines between administrative or regulatory search can sometimes, versus searching for criminal evidence, can sometimes get blurred. Generally speaking, if someone asks me beforehand, I say, hey, go get a warrant. Don't rely on that exception. Parole or probation searches are kind of distinct cases. Essentially, parole, someone is let out of prison early on the condition that they abide by certain terms and conditions. That typically includes a search condition. So that in that case, they've prospectively waived their Fourth Amendment protections and in receipt for prospectively waiving it, they're getting out of prison early. So you're giving it up, you get something in return. A probation search, someone may forego being in custody altogether. They may be put on probation. They may have search terms that are placed on them. Those search terms can vary based on the underlying crimes and circumstances that they may be given probation for. So for example, if there was computer crimes, maybe they, as a term of their probation, they'd be required to present any computer or electronic devices to a law enforcement officer. Contrast that with a different situation where, let's say you possessed a firearm, someone can come up and conduct a probation search on your person, even though they don't see a bulge in your clothing or anything that would otherwise give them reasonable suspicion to suspect that you're actually carrying a firearm because you've prospectively given up that right, or search your home. That can vary at wide circumstance. Yes, sir.
A real quick question. I don't know if you're going to touch on this or not, but you haven't spoken about automotive searches. Are we going to get on to that, or is that coming up?
I believe I do hit that a little bit later on in some of the slides here.
Okay,
Yeah,
thank you.
if memory serves. Again, Fourth Amendment doesn't give individuals an absolute right to privacy, and it does not prohibit all searches, only those that are unreasonable. We've been talking about some of the basic exceptions to the warrant requirement. In addition to plain view seizures, these exceptions to the usual warrant requirement, a cursory frisk or pat down, consent searches, searches pursuant to exigent circumstances, searches incident to custodial arrest, probation and parole searches, just to kind of summarize things as far as various exceptions. So here's another more specific example. Can an officer conduct a pat-down frisk for weapons if the officer has legally detained you? The answer, maybe. Normally, non-consensual searches are not permitted during a detention. However, if an officer has a factual basis to suspect the person being detained poses a danger to the officer or is carrying a concealed weapon or an object that can be used as a weapon, the officer is justified in conducting a limited search for the weapon without a warrant. That is a search on the outside of the clothing. You're searching for weapons, okay? And again, here we go. Cursory frisk / pat search is strictly limited search for weapons of the outer clothing of a person who has been lawfully detained. Weapons only, not for contraband or other evidence, okay? Now, you can always ask somebody's consent as well. Hey, for your safety in mind, do you mind if I search you to make sure you don't have any weapon on your person? If they say, sure. Then the officer doesn't need to be able to articulate why they had reasonable suspicion to believe that someone may have been carrying a weapon, because again, you've consented to that search versus the search consistent with reasonable suspicion during a detention. For a cursory frisk / pat down search to be lawful, the person must be lawfully detained for an investigative purpose. You can always have a consent encounter as well. So we're talking about an actual detention. Hey, I need to talk to you. You're free to go walking along. I want to talk to you. No, I don't want to talk to you. No, you need to stop. Now they're exercising police authority to stop you from walking away. It's no longer a request for a consensual encounter that you're now being detained if an officer is ordering you to stop, or they're taking other actions to limit you from leaving the situation. I think it's generally speaking, better communication on both sides of the fence generally results in better outcomes in my experience. Sir, you need to stop. I'm hereby detaining you. You're detaining me. Or you're walking, hey, I want to talk to you. No, I'm good. Keep walking. You need to stop. I'm sorry, are you detaining me, officer? Yes, I am. Then stop, okay? Because now they're asserting their lawful authority over you to detain you, and if you take actions to interfere with their lawful authority, then you can potentially be prosecuted for what's known as Penal Code Section 148 violation, resisting, delaying, or obstructing an officer in the lawful course of their duties.
Does the officer at that point have to tell the individual why you're being detained?
Generally they do, not necessarily though. Normally that's a de-escalation type situation where they'll say, look, there's a bank robbery over on 4th. I'm giving a gross example. You match his description, I just need to talk to you, we need to figure out what's going on here, okay? Normally there's some kind of a basic explanation, just again to keep it on a simmer versus a boil. Because, someone's walking along and a cop tells them stop them, and they're detaining you, they're stopping your freedom of movement and so forth. So generally speaking, there's usually what I see a discussion, a repartee, and some reason is given. There may be reasons not to do that, however, as well. So the answer is, in my experience, most of the time, not all of the time, because sometimes the officer may have a very good reason for not explaining why to you at first.
And do you eventually touch upon when you ask somebody to provide ID to identify themselves? Is that like a whole separate rules? Because I'm actually surprised to hear that when you handcuff somebody, they can still deny you searching them. That's the first time I've ever heard that. So I was wondering, what are the rules surrounding requiring somebody to identify themselves?
That gets complex. There are show ID states and there are no show ID states. California is a no show ID state in most circumstances. However, it can ripen into a situation where you can be arrested, or if you're being booked and you fail to identify yourself, it can also turn into 148. Frankly, I could do an hour on that alone. There are a lot of nuances to that.
So it depends, I guess.
It does depend. I know it's a lawyer answer, but that's the reality of it. An officer can always ask you, hey, I'd like, show me your ID. They can always consensually ask you, and you can say no. Then they have to make a determination whether or not they are, have enough to require you to identify yourself. So that's just a walk-up street encounter. Very different from say you get pulled over, show me your driver's license. You have to have a driver's license to drive on the road. And so that's a very different situation. They then have permission to ask you, and you're required to show it. If you fail to ID yourself, fail to sign the notice to appear, then you can be taken into custodial arrest, which is not something I recommend to folks. So for that, going back to this pat down, person lawfully detained for an investigative purpose, searching officers must be able to articulate specific facts which cause them to reasonably believe that a person is dangerous or may be carrying a weapon. So again, you're looking for a bank robbery suspect who utilized a handgun to engage in that robbery of the bank. This person is matching the clothing description and so forth. Likely have reasonable suspicion to do a pat down search there. You can also do search incident to arrest. So if you found some case to the contrary, I'd like to read it. But if someone is engaged in a custodial arrest, i.e. they are in handcuffs and not just detained, but arrested, then the officer is always going to search them for weapons. So if you've heard to the contrary, or you've read a case that said that, I'd like to see it. But that's not my understanding of the law. Different, you can sometimes handcuff during a detention, which is different from a custodial arrest. You are under arrest for X. They're always going to search you. So some of the factors in how you justify reasonable suspicion to conduct that pat-down search are set forth on the following slide. Clothing, bulge in the clothing, the size of a potential weapon, wearing a heavy coat when the weather is warm. Actions, trying to hide something, appearing overly nervous, acting in a threatening manner. Prior knowledge, the officer happens to know this individual who has a history of carrying weapons or engaging in violent behavior. Reason for the detention, stopped in order to investigate a serious violent or armed offense. Companions, lawful search of companions revealed a weapon or a potential weapon, which then is a factor the officer could utilize to justify searching you because you're with those people who had illegal weapons on their person. And again, these are not individual. You kind of look at all of these in totality. Location, stopped in an area known for violence or where the officer is unlikely to receive immediate aid if attacked. Time of day, amount of light, stopped during nighttime, stopped in an area with little or no lighting. Ratio, detainees outnumber officers. During a cursory frisk or pat-down search, an officer may reach inside a subject's clothing or pockets to inspect an object further only if, one, the object reasonably felt like a weapon or something that could be used as a weapon. Two, the subject's clothing is so rigid or heavy that the officer cannot rule out the possibility of a weapon or potential weapon. Again, we're talking about running your hands over the outside of somebody's clothing, typically for a pat-down frisk search. We've been talking about consent. Consent must be voluntary and obtained from a person with the apparent authority to give that consent. Again, the house rental room situation that I just discussed with you earlier. If the consent is valid, then the consenter has temporarily relinquished any expectation of privacy for the area of the item to be searched. Note that an unlawful detention invalidates a consent search. There's a difference between a consensual encounter and an invalid detention. So always keep that in mind. A consensual encounter is you stop, an officer says, hey, can I talk to you? You turn around and say, yeah, sure, what's going on? You engage in some discussions. Hey, do you mind if I search you for your safety and mine? Sure. Okay, no weapons. They continue talking, this, that, and the other. Versus an illegal detention, and then they ask for consent. It's kind of what's called, you may have heard the phrase, fruit of a poisonous tree. If you improperly detain them, then a consent search thereafter is invalid. You can't rehabilitate. Okay? You have to go linear in the analysis, if that makes sense. Again, another one, fleshing this out, exigent circumstances. We discussed that a little bit earlier. Peace officers may lawfully enter in an area in which an individual has a reasonable expectation of privacy where there's a compelling need for official action and no time to secure a warrant. Exigent circumstances means an emergency situation requiring swift action to prevent. And then you have several different bullet points here. Imminent danger to a person's life or safety, serious damage to property, imminent escape of a suspect, imminent destruction or removal of evidence. So a common example, officer gets a call, a neighbor calls 911, says they're hearing screaming, banging noises next door. The people who live next to them have known to engage in physical fights before. Sounds like that's what's going on. The officer arrives, is lawfully standing on the sidewalks are approaching the residence. They see two people engaged through a window, what appears to be some kind of physical altercation. They hear screams coming, stop, you're hurting me, etc. The officer can lawfully enter the residence under exigent circumstances, including forcing entry. in that situation to stop what appears to be a crime that is actually physically occurring. Okay?
And that actually happened, well, a few years ago. There was a hostage situation at a house down the street, and SWAT team came by to my house and said, hey, we're gonna ask your neighbors if they're gonna allow us to go on the roof. If they say no, we're gonna come into your house. Your house is the next best option, and we're just gonna have to go in. So they kind of warned me in advance. I told them, yeah, go ahead. And so they were in my roof. The snipers were there for like an hour. So that's one example as to they didn't need to have like any special permission because there was a hostage situation going down the street.
Yeah, the situation kind of dictated that, so. Yeah, a physical entry on your roof, yeah. Normally, they're gonna ask you for consent, hey, listen.
No.
And sure, so it sounds like they obtained consent from you. But yeah, the exigency would spur that kind of stuff, so, in potential circumstances. Another one is imminent destruction or removal of evidence. Let's say, for example, you're chasing a suspect, they run into a home, and they've got a bag which you believe is full of cocaine. Well, we get into hot pursuit and a bunch of other things, but generally speaking, you run through the open door, they're gonna follow you in there and restrain you so you can't start flushing cocaine down the toilet. Search incident to arrest. The example that you were talking about earlier. When a suspect is lawfully arrested and taken into physical custody, limited authority exists for peace officers to conduct a warrantless search of the person's person, also the property and area within the suspect's immediate control. So, for example, if you get arrested, you have immediate access to your vehicle. They can also search inside your vehicle as a search incident to arrest to ensure their safety and yours. Probable cause for lawful arrest exists. The suspect is taken into custody. The search is contemporaneous with the arrest. There's a lot of arguments that goes on about that, whether someone's arrested and sitting over on the curb, whether they still have legal access to the vehicle, i.e. to destroy things and so forth. Really depends on the facts and circumstances of any given case. That being said, if the vehicle is going to be impounded, there can be an impound search. An officer could also seek a search warrant to search the vehicle. There's a variety of different kind of exceptions when it comes to vehicle searches. I think you were asking about that earlier, sir. We talked about probation, parole. I'm not going to go back over that again. There's formal supervised probation or informal unsupervised. But in either event, generally speaking, when you're conducting a parole search, that's conditional release from state prison. You can have warrantless, suspicionless probation and parole searches are both reasonable under the Fourth Amendment, according to the California Supreme Court. Generally speaking, the officer has to be aware of the search conditions. Parole search conditions permit a search of a parolee's person, residence, and any other property under their control, for example, vehicle, backpack, etc. Probation search conditions depend on the specific terms of the probationer, which may be as broad as parole conditions, but may be narrower. And I think there was a recent case which talked about that. The officer has to have probable cause to believe somebody is actually on parole search. If they do have probable cause to believe that, which doesn't have to be actually accurate, then, in this particular case, the person was not, they'd actually gone off like just within a few days of being on probation, but the officer last checked knew they were on probation. That person had told them they were on probation previously, and the person did not tell them they were now off probation. There was a search of that person, and the court said that that was legal, even though they weren't technically on probation any longer, because the officer had probable cause to believe that the person was still on probation before the search was conducted, if that makes sense. So it doesn't have to be absolutely hyper accurate. You need to be pretty darn close, though. You may have to make reasonable efforts to verify, for example, that someone's on probation, and generally speaking, what the search terms are for them, because as noted, probation search terms can vary widely based on the underlying circumstances of the crime. Search someone's phone. Let's say, for example, someone is on probation for possession of child pornography. That would be a broader search term. The computers, electronic devices, and things of that sort may be one of their search terms, which is broader than, say, some kind of a property offense where you destroyed I don't know, a bicycle or a car or something like that. Generally not going to be able to go on someone's electronic devices is a term of probation in those circumstances. So that can vary. Talked about that. Warrant exception vehicle searches. Courts have created an exception to the warrant requirement when a motor vehicle is involved. They have determined that the risk of motor vehicle being moved to a different location in combination with the reduced expectation of privacy and people having vehicles justify a warrantless search as long as the search is based upon probable cause that the vehicle contains contraband or evidence of a crime, or the vehicle actually is evidence of a crime. For example, someone tried to use a vehicle to intentionally run somebody over to murder them. If officers honestly believe they have enough information to obtain a search warrant for a vehicle from a magistrate, it is legal for them to go ahead and search the vehicle without a warrant. For a search of a vehicle to be legal under the probable cause standard, the vehicle must have been lawfully stopped or otherwise be lawfully accessible. And again, the officers must have enough facts, knowledge, or training or experience to provide probable cause that the item that they are seeking will be found inside the vehicle. Again, there's also the search incident to arrest when someone is arrested inside the vehicle or in close proximity to the vehicle that they have access to. Okay? That's a very quick hit on search law, okay? And just based on the context, like I said, there are tombs of legal treatises discussing all of this in much, much greater detail. And there are exceptions to most every rule and exceptions to the exceptions as well. So I want to switch gears here for you. How are we looking on time? All right, we're still pretty good.
I think we're going on hour 2. You want to take a break, Sarah?
It's a little after 7. You let me know.
No, I think we can continue.
Can-
Yeah, let's
all right.
continue.
Continue for a little bit. Okay. So I want to switch gears on you. There's another aspect of the law that I think you should be aware of that peace officers are trained on. Again, required training regarding racial and identity profiling. This is set forth in Penal Code Section 13519.4. The California Post Commission requires that all peace officers in California complete 2 hours of training at least every 5 years on the topic of racial and identity profiling. What does that mean? It is defined in this subdivision E of 13519.4. For purposes of this section, is a consideration of or reliance on, to any degree, actual or perceived race, color, ethnicity, national origin, age, religion, gender identity or expression, sexual orientation, or mental or physical disability, in deciding which persons to subject to a stop, or in deciding upon the scope or substance of law enforcement activities following a stop, except that officer may consider and rely on characteristics listed in a specific suspect description. The activities include, but are not limited to, traffic or pedestrian stops or actions during a stop, such as asking questions, frisk, consensual and non-consensual searches of a person or any property, seizing any property, removing vehicle occupants during a traffic stop, issuing a citation, and making an arrest. That is the definition set forth in the Penal Code for racial/identity profiling. Peace officer shall not engage in racial or identity profiling. It's against state law to do so. Subdivision F of that same section. The required training must address a variety of issues, including the following. Number 1, identification of key indices and perspectives that make up racial identity and cultural differences among residents in a local community. Number 2, the negative impact of intentional and implicit biases, prejudices, and stereotyping on effective law enforcement, including examination of how historical perceptions of discriminatory enforcement practices have harmed police-community relations and contributed to injury, death, or disparities in arrest, detention, and incarceration rights and wrongful convictions. So this is what that 2 hours of training must include. Number 3, the history and role of civil and human rights movement and struggles and their impact on law enforcement. Specific obligations of peace officers in preventing, reporting, and responding to discriminatory or biased practices by fellow police officers, or peace officers, excuse me. Number 5, perspectives of diverse local constituency groups and experts on particular racial, identity, and cultural and police community relations issues in a local area. And again, the prohibition against racial or identity profiling in subdivision F, i.e. it must be clear that that is unacceptable behavior by a peace officer. In addition, there's another learning domain, post-learning domain number 3, which discusses, it's entitled Principled Policing in the Community. Law enforcement officers throughout the state are trained on the concepts of explicit and implicit bias in all police academies. Principled policing is the integration of procedural justice, legitimacy, implicit bias, and historical events, training on all of those subjects. Definitionally, implicit bias is defined as unconscious thoughts and feelings about people that may influence actions. Explicit bias, conscious thoughts and feelings that influence perceptions, decisions, and actions. Yes, ma'am.
Sorry to do this to you.
No, no worries.
This word struck me funny, and then I couldn't find it to ask you. Back to the second one there, identification of key, INDICES, what is that?
Plural of index.
Of what?
It's the plural of indices.
Oh, okay. Oh, index, okay. All right, thank you. Never heard that before.
It's rarely used. If you can weave it into dinner conversation, you're considered, like, you know, a pro at, you know, what's that word game where you make the words get points? I forget that. Scrabble. Thank you. All right. Definitionally, in Learning Domain 3, cultural competency is defined as the ability to understand, appreciate, and interact with persons from cultures and/or belief systems other than one's own, an ability to recover from inevitable cultural collisions, inclusive decision-making, advanced knowledge about cross-cultural differences, cross-cultural communication skills, diversity management skills, inclusive beliefs and values, awareness of personal biases and stereotypes, leadership commitment, and emotional intelligence. That is how learning domain describes the overarching umbrella of cultural competency, things to consider when you're engaged in policing in California. Definitionally, procedural justice is defined as treating people fairly with dignity and respect. Legitimacy is the public view of law enforcement as permitted to exercise authority to maintain social order and resolve problems. Legitimacy is enhanced through procedural justice, i.e. treating people fairly. It's a very long-winded way of saying police should respect people, non-peace officers, and people should respect police. I think overarching, if we can engage in that kind of fair treatment and respect for each other, then we're going to have better outcomes for everyone involved. Cultural competency. Peace officers are trained, it's a continuous learning process. That includes addressing and understanding implicit and explicit bias. It's not a set of demonstrable characteristics and skills that enable and improve an officer's ability to, it is a set of demonstrable characteristics and skills that enable and improve an officer's ability to understand, communicate, and effectively interact with people across cultures, in addition to improving job efficiency and performance, i.e., a law enforcement officer is there to do a job. The better that they understand the people who they serve and protect, and then that officer is going to be more effective in doing his or her job, and also minimize the opportunities wherein force has to be utilized, generally speaking. Cultural competency encompasses 4 components: awareness of your own cultural worldview, attitude towards cultural differences, knowledge of different cultural practices and worldviews, and cross-cultural skills. And again, typically in the academy, you know, you're kind of given this classroom type learning like we're engaged in here, but they also engage in role-playing to kind of help illustrate and bring some of these concepts down to a real-world level. You know, having a conversation with someone which may not hold the same worldview that you have, for example.
So these tend to be more of kind of like social, how to treat somebody, as opposed to like, okay, that culture tends to, I don't know, have a gun. That's the only thing that I can think of.
No.
It doesn't say that, okay, well, that's their culture, they can do that, but this other culture who doesn't practice having guns on them we're going to treat them differently
No, this is about how to treat people with respect and dignity.
in the communication.
Cross-culturally in their communication and interactions, et cetera. Yeah. It's not to say, here are stereotypes about this particular group and that particular group, you know, et cetera. No, that's not what the training is. It's the opposite of that, i.e. don't have those stereotypical viewpoints, treat everyone with dignity and respect. People are people. And, you know, give them respect until they're no longer deserving to be respected for whatever reason. And even then, whether you personally respect them or not, you still have to respect their rights, regardless of whatever your belief is.
Yeah, my question was more of a, you know, when it comes to the law is the law no matter what culture you practice, right? So if you're breaking the law, I'm trying to imagine a scenario where you'd have to treat a situation differently because of culture. So it sounds like it's not so much the situation, it's more of the interaction with the person that you have to be mindful of that culture, right?
Yes, that's correct.
But ultimately, if you're there to investigate something, culture doesn't really play a part into that. It's more of like, okay, we're here to investigate a potential crime, and we're going to follow the law, regardless of what culture you belong to.
That is correct. How you interact with a person while you're following the law may be influenced by this type of training. But ultimately, just because you're a member of a certain culture, if you're violating a penal code provision, it's irrelevant. In fact, you have to be unbiased in your application of the law.
Right.
And not single out a particular ethnicity, race, et cetera, for enforcement when you would otherwise not enforce it against somebody else. That would be racial identity profiling, which is prohibited by the law. So. Did I answer your question? All right.
Yes.
All right, just want to make sure. All right. I think now would be a good time to break, if I may, because I'm about to go into POBAR, which is an entirely different area of the law, if I wanted to give you the opportunity to ask me any questions about what we've been discussing tonight, before we kind of switch gears.
Do any commissioners need a break?
Okay, I'll keep going.
We're ready to just steamroll through this.
Rock and roll, let's do it. All right. So you'll hear this, it's so funny, it's Public Safety Officers Procedural Bill of Rights. You'll hear POBAR, POBRA, et cetera. I typically say POBAR, but essentially this is a state statutory scheme which governs rights and protections, due process rights, which are provided to peace officers in the state of California. There's also what's called a FOBAR, which applies to firefighters in the state of California, which is very similar, but with some minor distinctions between that and POBAR for law enforcement officers. So underlying the whole POBAR statutory scheme, the rights and protections, the legislature has stated constitutes a matter of statewide concern. The reason why we have this, in other words, the explanation. Effective law enforcement depends upon the maintenance of stable employer-employee relations. To assure stable relations are continued and effective services are provided to all people of the state, it is necessary that this chapter be applicable to all public safety officers as defined. I did not go into, there's an entire list of penal code sections which define peace officers in the state of California as to who that applies to. I will tell you with absolute certainty it applies to Santa Ana Police Department officers, peace officers, okay? Sworn individuals. This is set forth in Government Code Section 3300 at SEC and thereafter. One of the key provisions of it is Section 3303, which governs the interrogation of peace officers by their supervisors. That interrogation, we're going to discuss that a little bit tonight in some detail because it really varies on the facts and circumstances whether it's something that's even governed by provisions of POBAR or not. So number one, this kind of decision-making chain here. When the officer is under investigation and subjected to interrogation by his or her commanding officer or any other member of the employing public safety department. Number two, that could lead to punitive action. The interrogation shall be conducted under the following conditions. What is punitive action? It means any action that may lead to dismissal, demotion, suspension, reduction in salary, written reprimand, or transfer for purposes of punishment. So, and if all those factors do not apply, then you're not actually being interrogated. And we're going to discuss that again in some detail later on. Some examples of when it does and does not apply. 3303A, and these are some of the rules when you're actually conducting. Usually this is happening either leading up to or during a internal affairs investigation. Usually after, if you believe that an officer has violated policy, there is an allegation of violation of policy which you're investigating, then these rules for the interrogation of that officer apply. Number one, the interrogation shall be conducted at a reasonable hour, preferably at a time when the public safety officer is on duty or during the normal working hours for the public safety officer, unless the seriousness of the investigation requires otherwise. If the interrogation does occur during off-duty time of the public safety officer being interrogated, then that officer shall be compensated for any off-duty time. So generally speaking, you're not going to conduct an interrogation of an officer for a potential policy violation in the middle of the night. Usually it's going to be during regular business hours or that officer's normal shift. Typically, what I have found with most police departments is that they will generally work with the officer to reasonably engage in some scheduling of the interrogation. They'll say, we're going to interrogate you on X date at X time at X location. The officer may come back and say, hey, I've got a doctor's appointment. Can we do it another day? And the vast majority of the times they are going to say, yeah, what day are you? Then we'll do it the following day or something like that to accommodate the officer's reasonable request. Okay? Further requirements, subdivision B of 3303. Any officer under investigation shall be informed prior to the interrogation of the rank, name, and command of the officer in charge of the interrogation, the interrogating officers, and all other persons to be present during the interrogation. All questions directed to the public safety officer under interrogation shall be asked by and through no more than 2 interrogators at one time. So, for example, if I'm Officer Touchstone and I'm sitting here, all of you can interrogate me at the same time. No more than 2 of you can permissibly ask me questions. There may be other people present. Generally speaking, that's not the case. Usually it's just the 2 interrogators, so the person's asking the questions. But sometimes that varies depending on the nature and circumstances. Sometimes there may be other people who are listening to the interrogation in another room where there's only the 2 interrogators who are actually asking questions of the police officer. Okay. Public safety officer under investigation shall be informed of the nature of the investigation prior to any interrogation. This is pursuant to both statutory law, subdivision C, and also as interpreted by this case, among others, the City of Los Angeles v. Superior Court, commonly known as the Labio decision. And I wanted to kind of go through this to kind of illustrate where things kind of went wrong in this particular circumstance. This is a 1997 case. And discussion of the facts is somewhat warranted to kind of illustrate how some of these rules play out in practice. Officer Marinillo Labio was on duty as a Los Angeles airport police officer during the night of January 18th, 1996, and during the following morning. Lieutenant Martinez was the watch commander on duty at that time. The airport police is an agency of the city. During this shift, a fatal traffic accident occurred on Imperial Highway. Shortly after the accident, Lieutenant Martinez and Sergeant Hoffman stopped at the Lucky's Donut Shop. The owner of the shop, Mr. Chow, told them that he had seen a male Filipino officer drive past the accident scene in a marked police vehicle and without stopping to render aid. The officer had proceeded to another donut shop, Doughboy's Donut Shop. Well, this is not painting a very good picture here, is it? The stereotype of officers eating donuts. But these are the facts of the case, okay? I didn't make this up. I read it out of a case. Shortly after this conversation between Lieutenant Martinez and the sergeant, And that particular donut shop owner, Lieutenant Martinez, checked the deployment log to determine whether any officers on duty matched Mr. Chow's description. Officer Labio was the only Filipino officer on duty at that time. Sergeant Hoffman then went to Doughboys, the second donut shop, and asked the employee there whether an officer had patronized the restaurant at the time of the accident. The employee of that donut shop confirmed that a male Filipino had been there at about the same time as the accident, thus further corroborating the initial statement of the first donut store owner. This information was relayed from the sergeant to Lieutenant Martinez, who also spoke to another sergeant, Sergeant Montgomery, who was Officer Labio's immediate supervisor. They were talking to them to determine whether Officer Labio had permission to use a city vehicle at that time. Lieutenant Martinez discovered that Officer Labio did not have permission to use a vehicle that evening and asked Sergeant Montgomery to write a report documenting that fact. Later the same morning, a radio call was issued instructing Officer Labio to come to the watch commander's office. Officer Labio responded to the call. Upon Officer Labio's arrival, Lieutenant Martinez immediately began questioning him concerning his whereabouts and the use of a city vehicle during his shift. Lieutenant Martinez also asked Officer Labio about the route that he had taken in traveling to Doughboys. What is all this getting to, folks? You notice the nature and the focused nature of the questioning here? They're all kind of going towards whether or not he was actually driving the police vehicle, going past the scene, which he had obligation to stop and render aid at. And number two, whether he was actually driving a police vehicle when he did not have permission to do so at the time.
Why, I thought when an officer has a police vehicle out, that's with them all the time. So why did that matter that he stopped to go get a donut or something? I mean, I've seen officers in restaurants and everything with a vehicle parked out in the driveway, in the parking lot. I see it all the time where I get my hair done. Want me to tell you where I get my hair done?
No. So that's kind of going to depend. In most departments, you report for a duty shift and you're assigned a vehicle. Some officers have take-home vehicles. They're city-owned vehicles and they're permitted to take it home and utilize it for non-actual direct police work. Most of your marked patrol units, you know, the ones with the lights and sirens on top and they have Santa Ana PD on the side, generally they're, and if I say something incorrect here, Chief, let me know. But generally speaking, an officer reports to duty for a specific shift. He or she is assigned to a patrol vehicle for that shift. Sometimes some departments, you have the same vehicle all the time. Sometimes they're issued a new one every day they come in. It just really depends on the facts and circumstances. So this would be whether or not that officer was on duty at the time, and whether he had permission to use that actual vehicle. This is an airport police vehicle. Sometimes airport police departments do things a little bit different from your typical kind
Well,
of.
that's what I take this by reading that he was on duty and just left a minute to go get something to eat and then continued, I guess.
Yeah, it's
But to me, that
unclear.
doesn't make sense.
That is unclear to me. It becomes a little bit more clear on the next slide, though.
Okay.
But from what we've read thus far, I agree with you. Lieutenant Martinez, I got way behind on the fast forwarding, didn't I? Additional facts. Lieutenant Martinez had not informed Officer Labio that he was under investigation. He did not give him Miranda warnings or inform him of his rights under the act, and the act here being POBAR. When Lieutenant Martinez questioned Officer Labio, he knew that passing by the scene of the accident without stopping to render aid was a serious offense and that the officer could face disciplinary action if the allegation were sustained. Lieutenant Martinez testified that if passing by the scene of the accident were a felony at the time he interviewed Officer Labio, we would have had probable cause to take him into custody, i.e., this is a proceeding where the officer was being questioned, Lieutenant Martinez. Yes. He drove past the accident scene while in a marked patrol unit. Yes, ma'am. And no other officer was interviewed by Lieutenant Martinez concerning his or her whereabouts at the time of the accident. So what this is focusing on in here is whether or not the officer was afforded POBAR rights for interrogation, which we kind of generally discussed with you there earlier. So the court's decision is as follows. So this person, they conducted the investigation based in part upon the statements that were made by Officer Labio during that initial questioning before he was advised that he was actually under investigation for potential policy violation, before he was told the nature of that investigation, and he was noticed for the interrogation properly under POBAR, given his right to have a representative present, all of these things which I'm going to be discussing with you in further detail here. So the issue in this case was whether that preliminary question constituted a quote-unquote interrogation as defined under POBAR, or whether it was not an interrogation and it was simply day-to-day activities concerning the operations of the police department, which does not implicate POBAR. So, for example, you can come in and say, "Hey, where were you the other day?" You know, your sergeant says, "Hey, what are you doing right now? If that sergeant has no suspicion that someone is violating policy at the time, that is simply a day-to-day encounter, which is the vast majority of communications, even including questioning amongst officers and superiors to subordinates in a operation of a police department. The vast majority of the time, it's not deemed an interrogation under under POBAR. But this case was really talking and kind of honing in. When is questioning of a subordinate actually subject to the rules of POBAR? Because they asserted here that, no, that was not a POBAR interrogation. Officer Labio, who was subsequently disciplined, said, no, I think that it was. Thank you very much, based on all those reasons. The issue is whether Lieutenant Martinez's questioning of Officer Labio constituted routine or unplanned contact within the normal course of duty. We conclude that the trial court reached the correct result that the questioning can only be characterized as part of an investigation of Officer Labio for sanctionable conduct. The statements made to the lieutenant would be excluded. They could be used for impeachment, however. So what this case essentially said is, look, the supervisor under these circumstances knew there was a potential policy violation. The supervisor, the lieutenant here, had the ability to instigate or start a internal affairs investigation for a policy violation. And because he was engaged in focused questioning concerning facts which were relevant and pertinent to whether or not there was a policy violation, then Officer Labio should have been afforded the protections under POBAR. Because he wasn't, the penalty for that was the exclusion of everything that Lieutenant Martinez learned during that initial set of questioning. Now, questions after the IA was formally instituted, the officer was given the notice and was questioned there, that could all be taken into account as to whether or not there was a policy violation. But everything that the officer learned before, Lieutenant Martinez learned before, was excluded and could not be utilized in the disciplinary decision. Okay? Does that make sense? All right. Subdivision D of 3303. The interrogating session shall be for a reasonable period, taking into consideration the gravity and complexity of the issue being investigated. The person under interrogation should be allowed to tend to his or her own personal physical necessities. So what does that mean? Well, it kind of means what it says. So, for example, you may have an interrogation which may go on multiple days. If there are multiple policy violations which are being alleged and which are being investigated. So, for example, 200 instances of time card theft. Then that officer is going to be questioned on each one of those, whether or not there was actually a factual basis for the belief that there may have been time card theft or a policy violation associated with that. Or, let me see if I can give you another example. There was a case not too long ago, it kind of made the news, where multiple CHP officers were being investigated for saying they were actually working when in fact they were not actually working. They had a car or should have been doing this, that, and the other, but they were engaged in other activities. So some of those investigations, those interrogations, it's my understanding, because it involved multiple instances of that over a course of a long period of time, they went on for days because they were asked about each individual instance. What were you doing on this day? You're supposed to be, you were at this, you had this beat that you were supposed to be patrolling. Our GPS for your vehicle that day shows that you were sitting at the park for 7 hours straight. So you have an explanation for that. Those kinds of interrogations, they have to be for a reasonable period, taken into consideration the gravity and complexity. contrast that with a different example. One policy violation concerning a discrete event in both time and actions. You're not going to keep an officer there and beat him up for 8 hours over that unless there's a good reason for it. Okay? Just going to illustrate that. Subdivision E of 3303, again, governing the process for interrogation. Officer shall not be subjected to offensive language or threatened with punitive action, i.e., no cursing at the officer during the interrogation. And number 2, tell me or else. Not permitted under POBAR. That would be a distinct POBAR violation. Coupled with that, again, subdivision E, no promise of reward shall be made. Hey, look, just tell me the truth, and, you know, we'll get this sorted out, and, you know, that promotion you've been talking about, maybe we can see if we can make that happen. Can't do it. A department shall also not cause a public safety officer under interrogation to be subjected to visits by the press or news media without his or her express consent. That express consent is never given, in my experience, by any peace officer. If you have an example of that, I'd be interested to hear. Nor shall a home address or photograph be given to the press or news media without his or her express consent. Again, we're talking about the investigative process here, folks. So essentially, POBAR affords peace officers privacy rights during this process as it's winding its way through. And these could result in violations of POBAR, which could have repercussions, both monetary as well as exclusionary, as we just discussed in the Labio case. Subdivision F, no statement made during interrogation by a public safety officer under duress, coercion, or threat of punitive action shall be admissible in any subsequent civil proceeding. This subdivision is subject to several qualifications. Not applicable to federal court proceedings. So we're going to discuss something in a little bit called Liebarger admonition. I don't want to get too far ahead of myself in that, but this is state law. As I mentioned to you earlier, I practice a lot in federal court. In fact, I was in the Santa Ana federal court building right down the street this morning for a proceeding. Federal courts are mildly interested in California law. But it doesn't govern their actions. Federal law governs federal judges' actions. So, and through the supremacy clause, if a federal law says contrary to state law, then the federal law is going to trump in federal court proceedings. And these POBAR situations, for example, here, a coerced statement, they are admissible in federal court. So, state law, state court, different answer. But in federal court, this is irrelevant, okay? It may be admissible in state court as well, depending on meeting certain procedural requirements. Specifically, something known as a pitches motion would need to be filed. Next slide, and again, I'm behind, my apologies. Subdivision G. The complete interrogation of a public safety officer may be recorded. If a recording is made, the officer shall have access if any further proceedings are contemplated or prior to any further interrogation at a subsequent time. The officer shall be entitled to let me stop there for a minute. So typically speaking, an officer who's being interrogated is going to have a legal representative with them. He or she will also be recording the proceedings. So you will have, the interrogating officers will have a recorder on the table. They'll go on the record. They'll say who all is in the room, and I'm recording these proceedings. The time is now X. We're located here. So-and-so's in the room. So-and-so's also in the room. Officer Smith is in the room. How do you spell your last name? His or her legal counsel is typically there with them. They're going to state their name on the record as well. Usually their legal counsel will also bring a recording device and place it on the table so that you have 2 different tape recordings of the proceedings, which may be utilized later to be transcribed. So if an officer utilizes an appellate route, such as an arbitration or something along those lines, okay? If you are going to do separate interrogations, let's say, for example, now this can get a little bit, there's a fine line distinction between the two. One interrogation can go multiple days and still be one interrogation, even though it takes place over several days. If you go back and do a second interrogation at a later point in time, then prior to that, you have to disclose all the prior recordings that were made during the first interrogation session to the officer, even though you know that he or she already has a copy themselves because they recorded all the proceedings, okay? And there's some case law on that, including one that was actually come out of the city of Santa Ana. In addition, officers shall be entitled to transcribe copy of any notes or to any reports or complaints made by investigators or other persons, except those which are deemed by the investigating agency to be confidential. No notes or report deemed confidential may be entered in the officer's personnel file. Officers being interrogated have, again, the right to bring their own record in and record any and all aspects of the interrogation, which is what I was just discussing with you. So let's assume, for example, there's competing case law on this issue, actually. You have Anna versus City of Santa Ana, which was handed down in June of 2017, which talks about you have to give, before you conduct a second investigation, you have to essentially give all non-confidential materials to someone. There's a subsequent case that interpreted that, saying, again, non-confidential means non-confidential. And the way the process typically plays out is that when, usual course of a internal affairs investigation, there's a complaint that comes in saying officer did X, we believe that to be a policy violation, used excessive force, did whatever, sexually assaulted me, whatever the allegation is, has to be investigated under state law. Usually the first person they will interview is they're going to interview the complaining party. What are you saying exactly happened? Was anybody else present? You know, well, yes, so-and-so was there, he or she saw it as well. The investigators will then interview those people. They will determine whether or not the officer was in that location. So, for example, most police units have GPS location devices on the roofs so that they can track the vehicle's movements. So, for example, a complaining party says, we were in MacArthur, I don't know any of your local landmarks, so I'm just making up an example. We were in MacArthur Park, he pulled me over for a traffic stop and he sexually assaulted me. The investigating officer will look to determine whether or not the GPS puts that officer's vehicle in MacArthur Park at the alleged time, which at least puts that person in a place of opportunity to commit that as sexual assault. Were there any other witnesses? They'll investigate all of them, gather all of the evidence, any other persons who saw it, anything else, any communications, which may have indicated that there was an interaction, if there's a police report, body-worn camera footage of an interaction with the complaining party at that particular time and location. All that evidence will be gathered. Typically speaking, the last person who is interviewed is the officer. After the investigation is gathered, all of that evidence and put it together. Clearly, you do not usually give copies of all of your evidence to a person you're about to interrogate, because that would allow them to change their answers. That would allow them to try to intimidate witnesses, perhaps, and things of that sort. So sound investigative processes usually dictate that all that information is kept silent. So the question in this case, Anna versus City of Santa Ana, as well as some of the other cases that are interpreted, was, let's say you interrogate the officer during the first session, and you gain additional information there. The officer, for example, says, no, I didn't do that. And in fact, Officer Jones was there with me on that traffic stop. You need to talk to him as well. So then, okay, we'll go follow that investigative lead, talk to Officer Jones. Officer Jones says, well, no, I was with him that night, but it was 2 hours earlier. I think he's wrong on the timing, which now calls into question the subject officer's statements about Officer Jones' presence. So there may be a second interview wherein that interrogation happens the second time around. Officers now, is not uncommon for them to say, I want all your evidence up until the first point of the first interrogation. And the cases say if it's confidential, i.e., my argument has always been if it would impair the effective completion of that investigation, then you're holding it as confidential. You do not need to disclose it. What is clear is that you do have to give them a copy of the prior recording from the first interview session, and if you prepared a transcript, you have to give them a copy of the transcript. That is clear. This other stuff, there's still some arguments about the scope of it, but I think the better argument is you not required to disclose it because it's confidential and that it would impair your investigation in conducting that second interrogation of the officer. Okay? So then you go in and you would follow up with that officer saying, we spoke to Officer Jones, and Officer Jones said, yeah, he was with you on a traffic stop that night. It was in that same park, but it was 2 hours earlier. So you have any explanation for that? And he or she would then give a subsequent answer, et cetera, et cetera. Ultimately, the investigation is going to be concluded. The investigator is going to reach determinations concerning the factual basis for it, whether or not there is, by a preponderance of the evidence, they can sustain or they believe that certain things, factually things happened, which would then give rise to certain policy violations. Clearly, Santa Ana Police Department does not tolerate sexual assault by its police officers. And keep in mind, we're only talking about the internal affairs investigation. There may be parallel criminal investigations because sexual assault is a crime in the penal code. So that may be going on by the Orange County District Attorney's Office, the State Attorney General's Office. Remember, we were talking about all the various investigative agencies. There are sometimes parallel investigations that happen during some of that. So it gets somewhat complex and with different goals and outcomes that they're looking to determine. Here, we're just talking about policy violations, which would subject an officer, if there's an allegation of sexual assault, probably termination. Okay, they're going to be fired. So if the investigation sustains those charges or believes there's by a preponderance of the evidence, the violation should be sustained, then that investigative report is then sent with what's known as a notice of intent to impose discipline. At that point in time, the full investigation has to be disclosed to that officer. Okay, so everything, but not before that interrogation, which could allow him to twist and squirm out of and or intimidate witnesses and things of that sort. But if everything that you're going to base your discipline on has to be provided to the officer. And then you have, and this varies from jurisdiction to jurisdiction. The officer gets that, they can then request, they have a time period, it's usually set forth in your state municipal, or excuse me, your municipal code for the city and or your MOU saying you have X number of days to request a hearing. It's known as a Skelly hearing. It is a pre-deprivation hearing. So in other words, this is what we intend to discipline you with, i.e. our intention is to terminate your employment with Santa Ana Police Department. You have 10 days to request a Skelly hearing. That can generally happen. Is it happen with the chief here? The Skellies? Yep. Done by the chief? Yep. You can also have what's known as a super Skelly, which may go to, you have a Skelly in front of the chief, then it may go to a city manager. It happens in some jurisdictions, or another designee, his or her designee. It gets complex from jurisdiction to jurisdiction. Generally speaking, though, it's the chief that conducts a Skelly hearing. The chief's obligation is to go in and listen with an open mind. This is where the investigation has led me. This is where it's led me to the discipline that I'm proposing, in this case, termination. Then the officer is entitled to come in and say his or her last word. Well, Chief, look, I'd like you to consider the following facts. I've been an officer here for 25 years. I've never been disciplined for anything. You know, I'd ask you to take my record into consideration, and I screwed up. My example of sexual assault is very extreme. I don't think that outcome is going to vary if that investigation has led to that square. But in other circumstances, the Skelly can be meaningful because the chief may have not considered things, or the officer may express remorse and may vary the ultimate penalty, the notice of final discipline that is imposed against that officer based on some of the statements made during that Skelly. Contrast that with another scenario which has occurred. Let's say we have a less drastic policy violation than sexual assault, which is also criminal behavior. Let's say that the officer inappropriately used a police vehicle. They're making a donut run, like our Labio case, okay, whatever the case may be. And the notice of intended discipline there is 1 day off without pay, or 8 hours, whatever your shift is, 10 hours, 12 hours, depends, varies from department to department. The officer then comes in a Skelly, takes a totally opposite approach, expresses no remorse whatsoever, and says, and by the way, I'm going to do it again next week. Thank you very much, Officer Jones. Final discipline, 2 weeks off, retraining on proper use of police vehicles, and potentially demotion. Let's say it's a sergeant, and we're going to kick you down to a patrol officer again. So that is a pre-deprivation hearing. They can go either way. They can go to the officer's benefit, i.e. a reduction in the proposed discipline, or alternatively, and particularly with respect to supervisors, who you expect to lead and train your patrol officers, the Skelly can go in a different direction, and you can have actually more discipline imposed than when you walked in there. So, does that make sense to everybody?
A couple quick questions
You
for you.
can talk yourself out of a job, in other words, when you might have just been suspended for a period
Your
of
own
time.
worst enemy.
Yes.
Couple quick questions for you. You kept referring to having their lawyer present. Is that something that's typical?
Absolutely.
Oh, really? But this is not a legal proceeding, correct? This is an internal disciplinary action, correct?
It is an administrative proceeding which could result in a person losing their job and/or being demoted, et cetera. Yeah, they have a right to legal counsel.
Oh, interesting. Even though it's not criminal, there's no criminal intention.
That is
Interesting.
correct.
And I take it the union is involved in this also, or?
So you can have both the union representative and legal counsel. Most people dispense with a union representative and just have legal counsel. In my experience, because they want someone who, look, some of the union reps are very well versed in POBAR and very knowledgeable. Generally speaking, they want an attorney in the room because that attorney might be the person who's going to be representing them in a subsequent arbitration. So they want the same individual involved from inception of the proceedings and advising them along the way.
It just seems like it's a little bit of overkill. I mean, in most typical jobs, you would not have an attorney present if you're being disciplined. You see what I'm getting at? I mean, it seems like you're attorney, you're throwing down the gauntlet out the gate. Because you're almost saying, I intend to pursue this legally. You as an individual against the city of Santa Ana or the police department.
Maybe, maybe not. It doesn't necessarily mean a lawsuit. It just means they're getting representation during that administrative process to ensure that the department is following procedures required under POBAR and how they're conducting the investigation, the interrogation, et cetera.
But when you say procedures, it's not law, correct?
No, it is law.
This is law.
Yes, sir.
Okay.
It's government
But-
code
but
section. It's California
It's a little
state law.
confusing because it's not a trial. You see what I'm saying? It's like you have an attorney present, but it's not a trial.
That is correct. It's not a trial. They're purely there to advise.
So the attorney can speak for this individual, correct?
They can. In fact, sometimes they may ask their own questions at the conclusion of the interrogating officer's questions. A lot of times they will speak up during the Skelly hearing. In addition to the officer, they may try to shut the officer up, try to prevent him or her from jumping off the cliff like I was discussing there. You've said enough, stop. You know?
Yeah. No, I understand. It just, again, it seems a little odd to me, to have an attorney present during something like that. I understand now that the legal implications because of the statute or whatever you want to call it. Yeah, it just seemed a little odd to me. Again, it's not a trial, it's an investigation, and to me, having an attorney there kind of limits that a little bit.
They can't interfere with the investigation.
No, but they can advise the person not to say anything, or they can speak. They cannot.
No, we're going to get into that in a moment.
Okay.
And
Thank-
I just wanted to point out too, I'm really glad that Mr. Touchstone is speaking to POBAR. This was specifically requested, and it's actually part of the ordinance. And the reason why is because this will have such an overlap in terms of the investigations that this body conducts when the independent oversight director is appointed, because this is the governing law. And so I think that just holistically, it's important to kind of understand what is out there in terms of protecting police officers and the laws that govern them, so that obviously this body is going to want to engage in a lot of fact-finding, is going to want to engage in, the independent oversight director has subpoena power to an extent. So there is going to be a desire to, again, conduct that fact-finding, get to the bottom of things, uncover facts and circumstances, and POBAR will always be overarching. It is always going to be an overarching set of laws that we all have to abide by. So again, I'm very glad that Mr. Touchstone is speaking to this issue because it is going to kind of guide us in a very large way moving forward.
Yeah, this is state law, which is supreme to municipal law.
Understood, yeah, I didn't, again, it's just that it's not a trial, but there's a lawyer present. That's what seems to be a little odd.
I hear you. So let me put it in a different context to maybe reduce some of the oddness for you. In disciplinary proceedings for physicians, where they're in front of a physician review board who may revoke their licensure, they're generally represented by counsel as well, even though it's an administrative proceeding, because it has lasting and profound implications on that person's career. Certainly in a licensure revocation proceeding, their ability to practice in any given area for employment that they've chosen.
Not to minimize this, but it seems like the investigation, quite frankly, is really a trial in essence, because you have limitations on how the evidence can be, lack of a better term, evidence can be collected. You know, because it even goes into, you need to give the guy the Miranda rights if there's certain things involved. So it's almost an internal trial in a way, the only difference being there's no judge, because you have a counsel there to advise you. And I assume the police department's gonna have counsel there to advise them.
Yep.
So it is kind of like a trial. The chief can have, is kind of a judge almost in dispensing the punishment or what have you.
Well, here at Santa Ana Police Department, the only person who can actually administer discipline is the chief of police. Everything, the investigation up to the notice of intent, up to the notice of adverse decision, which is, hey, here's the discipline we're gonna give you, that's all only given by the chief. Everything from that point forward is recommendations to the chief based on the investigation. To your point about the attorneys being present for the officer who's being interviewed, they are there really to serve a purpose down the line. Because during these interviews, the attorneys are very limited in what they can and cannot do. And they'll get to that. I mean, they're really there to make objections, ask clarifying questions. They cannot tell their client to refuse to answer, because there are serious implications if they refuse to cooperate with administrative investigations. This is the law. This is what we follow it in the police department. It is very structured. It is very rigid, which is why it does take some time to get through these investigations, because of the way the law is written and the rights that are afforded to the officers. This is simply the playbook, if you will, for administrative investigations involving officers.
No, I understand better now. Again, it's not a criminal proceeding. It's just, again, it's almost procedural like a trial. You have an investigation, the officer has his rights of protection, the city has their rights of protection, there's evidence rights, there's all those things. It's, lack of a better term, it's an internal trial. For discipline, for discipline only. I fully appreciate it's not criminal, that's a different matter, and that would be taken into the courts.
But a trial would have a jury.
No, I understand that. But that's what, it's just, if I'm characterizing that wrong, let me know, but it does seem like it's an internal trial.
You could certainly look at it from that perspective.
And it is not public either, correct? There's no,
That is correct.
okay, was my other question. I appreciate it, thank you, and
Yeah,
thank you for your explanation.
This would be what's called a bench trial, AKA a judge.
Exactly.
The chief is that judge at this level. I will tell you, there are, much like we were talking about the general civil case, there's other levels.
No, I understand. Again, this is
Yeah.
a disciplinary action. It's not civil, it's not criminal, so,
Even the disciplinary action itself. So
yeah.
the notice of final discipline is issued. Generally speaking, your MOU or your municipal code or your personnel manual, given whatever jurisdiction, will provide you with appellate rights. So you may go to an arbitration. You may go to binding arbitration, which means the arbitrator's decision is final. You may go to a personnel board, which is similar to what, there may be 3 or 5 people on it, and they may have final binding rights on the officer. If you go to, most departments are still, you just go to arbitration. The arbitrator can issue what's called an advisory opinion, which will then go to the city council. I'm not sure what Santa Ana does, but the city council, by majority vote, can either accept the arbitrator's opinion and adopt it, which would be conclusive at that point, or alternatively, they may modify it, or they may reject it and make their own decision, but there'll be a full record there. From that point, an officer, if they don't like that decision, can file a what's called a writ proceeding, an administrative writ, under 1094.5 of the Code of Civil Procedure, which then takes it to a quote-unquote judge with a black robe on.
Gotcha.
And he or she makes a decision on it. If they don't like that decision, they can appeal that to the Court of Appeal in California State's court.
So now we've entered into the court system at this point.
If they don't, yes.
Okay.
So that's why I say he's the initial judge, but there's a bunch of judges later.
Yeah, no, I understand that. Yeah, if they
Yeah.
if they choose to pursue this, if they feel it's unfair or whatever.
Correct.
And the arbitrator would be out of the regular arbitrator pool, or would it be-
Correct.
Okay, so it's not anybody that has anything to do with this city or anything else.
Our city right now, we use the personnel board model, where, individuals that are selected by the electeds to sit on the panel will hear the case. It's a mini trial, so to speak. And then they issue their findings as it relates to the evidence that's presented to them. And then past that, there's the other layer that was just discussed.
No.
There are multiple layers
Yeah.
of appeal that go with these cases.
Now, during this period, and I don't mean to drag through the dirt on this, is the officer still paid? Is he still on duty, or what are the stipulations on that?
It depends.
It really does. It depends on the severity of the policy violation. Was it criminal? Was it not?
Well, yeah, I can understand
A lot of
criminal,
that
yeah.
stuff really depends. I've seen it done both ways here, where the officer will get paid all the way through. He or she gets paid all the way through the end of the notice of adverse decision, which is the chief heard the employee, rendered his final decision. Discipline is then imposed. If they're terminated effective once they sign that document. If it's a suspension, they'll serve the suspension. They could still go appeal, and if they win their appeal, they'll get their back pay, they'll get their jobs back or whatever. But we essentially have the employees serve their discipline upon signing of the notice of adverse decision.
Okay, so that's a good point, though. They can be reinstated if the actual court finds them in the right.
The personnel board
Or the personnel board.
could actually say.
Oh, at that level, it could be done.
They could overturn the findings and reinstate the employee.
Okay, I'm just assuming that we've gotten into the court system. The personnel board agrees with you, and they go into the court system, and they say,
Every step, they could basically overturn the findings.
and receive their job back, and all's good.
And the chief now has an employee working for him or her again who they had already decided shouldn't be working for him.
No, I understand, and that's my questions, how they would be coming back.
Is it my understanding that the personnel board has been disbanded? Because I think I heard the council mention something about that. If we were gonna have the police oversight commission, then there wasn't a need for a personnel board. And my second question is, do we have that authority that the personnel board has, that we can reinstate an employee?
No.
I'll let Jonathan answer your last question, but we do still have the personnel board in place today. In fact, there are personnel board proceedings ongoing as we speak. We also have arbitration situations that are going on as well. So we're utilizing both models. I'll let Jonathan answer how you come into play.
Take it away, Jonathan.
The ordinance does not authorize or give this body the authority to take disciplinary actions. You have the authority to make disciplinary recommendations. Again, we've talked about the different routes that can go to the police chief, city manager, and ultimately to council, if those routes are activated, if you will, to make it to council. But the body does not have the authority to make decisions. That is left for the personnel board. Whether or not the council will choose at some point in time to amend the current ordinances to disband the personnel board, I couldn't speak to that. I mean, it's always a possibility, I suppose, but as far as I know right now, that's not something that that our office is currently working on, making those amendments.
Real quick, the personnel board does not just do police discipline either, correct? It's citywide, correct? So disbanding would be not disbanding, but limiting their influence on the police side of things, correct?
If that were the route that council were to take, yes, it would be narrowing, because
Exactly.
it's all departments. I think there's one's going to be coming up next year that involves a zoo worker.
Yeah, no, that's my understanding of the personnel board is it's citywide. It's not isolated to the police department.
Commissioner Pereira, go ahead.
Yeah, my understanding to give such powers to the commission to be able to fire or reinstate, I believe that might be a charter amendment, right? That needs to be taken to the borders. Is that correct?
It would seem to me that it would be, I don't know the exact answer.
Okay, I remember when.
But
Yeah.
if the personnel board were established by charter, to amend that would require, it would require a charter amendment,
Yeah.
which would be voted on.
Yeah, I remember the city council when it was debating how strong the police commission, how strong the powers were going to be. I think they were thinking about possibly pushing something to the borders for a charter amendment to make it stronger. So perhaps maybe as a commission we can do a follow-up with our council members with some recommendations. But I have a question, maybe, and let me know if this is still an ongoing case or we cannot talk about it. But I'm wondering to the conversation we were having regarding the disciplinary process, the process of interrogation, then recommendations of discipline, where the personnel board comes in place or the chief comes in place, and if the decision is made, if someone's restated. I wonder if this is a good example. Could it be the one where we had that incident a couple years ago where with a police officer in a cannabis store that was captured on video camera? I believe that maybe the personnel board might have made a decision, the chief made a decision, but then later those officers were reinstated. Is that a good example of that?
That's a little before my time. I'll turn it over.
I wasn't in charge of IA at the time, and I can't remember. I know there was something that occurred on the personnel board, but I don't know what the exact action was. So I think it'd be a little, I don't want to spread any false information, so I don't know for sure.
Thank you.
And I suppose our recommendations can be sent to the personnel board too, right? I mean, our recommendation would be public.
I'm struggling a little bit to answer that. So are you saying that as a body, you would be working with, say, the independent oversight director to fashion a report that recommended that council, and for lack of a better term, divert the authority away from the personnel board to this body to make actual disciplinary action? Is that what you were asking? I'm sorry, Chair.
Yeah, well, we don't have that authority that the personnel board does, but I feel like if we, as a body are going to be investigating something thoroughly, I feel like what the decision that we make as a body would be useful for the personnel board to consider when they're, investigating perhaps the same thing in what they're deciding what the appropriate action is for that case.
So is what you're asking, would the recommendation, the hypothetical officer uses excessive force, independent oversight director investigates via all available means that are lawful, the determination this body makes is that yes, it's sustained, the excessive force occurred, and that the officer should be terminated. Okay, so that's the conclusion from this body. And simultaneously to that, because there's multiple tracks operating here, so simultaneous to that investigation, let's say you have an internal affairs investigation, and internal affairs, because I'm trying to have this reach the personnel board. Internal affairs reaches the same conclusion and presents its findings to the chief along with yours, and the chief terminates. Now that officer who was terminated appeals to the personnel board, and has his hearing. So would the personnel board have access to, or would it be helpful for the personnel board to have access to this body's report and findings? Is that the question?
Yeah.
I think it would. I think it would. And I think that, I don't think that there's any, I mean, James, correct me if I'm wrong, I don't think there's any reason why the personnel board would be restricted from having access to that report unless there's evidentiary objections that the personnel board would entertain.
I can't think of any reason off the top of my head. So if you're talking about a specific officer, that would need, you need to maintain the confidentiality of it. Your personnel board proceedings are confidential in nature. There's case law stating that.
They're open for public comment at the beginning.
Right,
And
when
then the
you're-
room gets cleared for
Sure.
the actual trial.
Sure,
Right.
yeah, which is consistent. But yeah, your recommendation vis-à-vis a specific officer, an exchange of information between internal city bodies is not a disclosure. So, then I don't see any impediment to that I can think of. I think I read the ordinance
Yeah.
establishing the commission before my
Yeah.
first, I didn't reread it before tonight, to my chagrin. But as I recall, yeah, you are making advisory, recommendations to the city council with respect to your determinations, but I don't know why that couldn't be shared with the personnel board or something like that. It's technically outside the purview of what's set forth in the ordinance, but I don't know.
Yeah.
I'll defer, I don't wanna get too far out of my lane on that stuff, frankly.
Let me ask something too. Now, are we gonna be doing what we're doing while this personnel board is doing what they're doing? Is it separate, or are we overlapping functions here? What's going on?
Please.
In a perfect world, the personnel board is essentially convened when the investigation's over, the officer's been served, discipline has been served, and the employee is choosing to exercise their appeal rights. So that investigation's done. So in theory, if, let's say, the complaint comes in via the portal, we also get a complaint mailed to us, we conduct our investigations. Our investigations, before it ever gets to the personnel board, would in theory be done. And so the personnel board isn't necessarily conducting any investigation. They're like literally a mini trial where the commissioners are sitting on this commission, listening to the evidence presented by both sides as it relates to the investigation.
No, I appreciate that, but we've got our commission manager who's gonna get the information and bring it to us if he deems necessary or thinks it should be. A decision's made, he goes back, the manager goes back, and does he say, okay, I'm gonna give this to the personnel board? He goes, I'm gonna give this to the council? I mean, how do they decide where it goes? At what point does the personnel board get involved? I guess is what I'm not clear about.
The personnel board, that option is exercised by the employee who
Okay.
is wishing to appeal
Only in an appeal?
Only on appeal.
on
Got
it.
it.
So think of the personnel board
got
as
it.
as the first appellate court.
No, I got it. Once
Right.
that's all I need, yeah.
And I guess just to clarify, Vice Chair, you did mention, well, could our investigation be happening at the same time as the personnel board? Theoretically, I suppose, because of the 1-year statute of limitations that this body operates under, and I don't know, I mean, I know the personnel board is a little impacted right now, but it is theoretically possible that officer gets terminated, or Internal Affairs conducts its
Discipline.
investigation, officer's terminated, officer appeals. We're still within the 1-year time frame of the alleged misconduct when the complaint, maybe the officer himself files a complaint and says, I was discriminated against by the chief of police, and he fired me, and so and that occurred on this date. So I suppose it is possible that because of that 1-year statute, that possibly this body could be investigating something while the personnel board hearing is occurring. It's possible.
No, I appreciate that. Once you said that that's an appellate type thing, then that makes it clear.
Sure.
So the decision would be made by the chief, then goes to our director, and then comes to us, and then kind of goes back that route. Fair statement?
Yes.
Thank you.
All right.
I have two questions I've been waiting for the last half hour to ask. Let's go back a few chapters. What is the word scullery? Did I hear that? Oh,
Skelly,
how do you spell that?
Skellly. It's based on a case.
Oh, what is that about?
It's about due process. So essentially, you make a determination, I forget the full name of the case, it's just always truncated as Skelly. You get the opportunity before you have a deprivation of rights to have a say to the decision maker. And the decision maker is supposed to be open to listening and hearing new evidence and new perspective on things and so forth before he or she makes their final decision. And like I said, that's your chance to throw yourself on the mercy of the quote-unquote court of the first level, or alternatively, provide additional information, which may reopen an investigation. I've seen that happen before too. Well, you really need to talk to this other person. Sometimes they'll go back, reopen the investigation, and they'll re-skelly them after getting the additional evidence. And then after that Skelly hearing, which is very informal, typically it's sitting around in a conference room, chief's going to be there, chief's going to have his legal counsel sitting with him, subject officer's going to be there, he or she's going to have their legal counsel sitting with them. It's recorded again, and they sit usually very informal, typically 30 minutes or less in my experience. More complex investigation may entail a further longer review of evidence and or mitigating circumstances that gets brought up. But it's a talk. There's
Okay.
no,
Kind of get things settled.
yeah,
huh?
there's no objection, overruled, it's just, you're talking a little bit.
Okay, the other one I wanted to ask, you brought up the Oversight Director. Do we have one yet for this group?
We do not have an independent oversight director. There have been proposals that have been submitted to council, and they're currently under council
And
review at this
what will
time.
be their position? What do they do with us?
They have a very, very important role. The independent oversight director essentially acts as the conduit or the vehicle for all the investigations that this body would be undertaking. Data gathering, fact-finding, analysis even, and they also would act as kind of a direct liaison to the city attorney's office, to the city manager's office, to the police department. So they are going to operate this person will operate at your direction, knowing that they technically work for the council, because they are appointed by the council, but they will work under the direction of this body.
And they will come to our meetings too then, to listen what we have to say? Okay,
Yes, they will.
interesting. Thank you.
You've outlasted me. I need to take a break at this point, okay? So we could take 5 and.
Yes, let's go
I'll
ahead
as-
and
I'll-
recess
I'll go as
for
long
5
as you
minutes.
want and
gonna
as many
ask you-
slides as I have here. I've got about another 15 or
know.
20 slides.
I was gonna ask, do you have an estimate about how much longer you think you have?
Probably 30 minutes. Maybe a little bit longer.
Yeah, let's go ahead and take let's recess for 5 minutes, and then we'll come back and we'll finish.
Okey-doke.
Could we get another more water bottles, please? Thank you.
right, we ready?
Didn't do anything all February for his vacation.
All right.
What's the name?
All right, thank you for your indulgence and patience tonight. I know this is not the most scintillating of information sometimes, but let's go ahead and push on through. So, as the chief was kind of...
One second.
Oh,
Madam Recording
apologies.
Secretary, we're ready to restart the meeting.
Yes, Chair Vega.
This meeting is resumed. The time is 8:21 p.m. and we are continuing with training.
All right. I know the chief was kind of chomping at the bit to discuss the Lieberger decision. So the repercussions of failing to answer questions or this, that, and the other are kind of set forth in this case. I will tell you, this is the California counterpart to a federal court decision known as Garrity. It's, we call it Lieberger here in California because this is a California Supreme Court case which kind of discussed this, but it derives from a United States Supreme Court decision, so sometimes you'll hear some people reference it as Garrity Lieberger. Okay? And what this is this. The court states, as a matter of constitutional law, it is well established that a public employee has no absolute right to refuse to answer potentially incriminating questions posed by his employer. Instead, his self-incrimination rights are deemed adequately protected by precluding the use of his statements at a subsequent criminal proceeding. If it is reasonable to believe that an officer can face criminal penalties for his or her actions, they must be advised of their constitutional rights. So, and there's a kind of a little card typically that is read. And I want to pause here. So what is this? Where do we start from? If you've all heard of the Fifth Amendment right to remain silent, presumably, right? So everybody, including police officers, they are people too, have Fifth Amendment rights to refuse to incriminate themselves. However, as a condition of their employment as a peace officer, the courts, both federal and state courts, have carved out an exception to that because of the needing to foster the integrity of administrative investigations and the ability to make decisions concerning someone's continued employment. There are many policy violations, not all, but many. So, for example, use of excessive force, which can also result in criminal charges being filed against that officer by either, as I noted earlier, Orange County District Attorney's Office, California Department of Justice, United States Department of Justice. So, in many occasions, the officer will force their statements to be compelled. They're saying, respectfully refuse to answer the question. If that is the case, then the Lieberger admonition is given. Or alternatively, if the investigator believes that there's going to be potential criminal charges flowing, they'll just go right into Lieberger and compel the statement. It really depends. Some jurisdictions are very different from others. Most of the time, many times they'll ask, and if the person says, I respectfully refuse to answer the question, usually the employees are given a card of exactly what to say, which has their rights, which then implicates Lieberger to be ordered, okay? So what it means is this. You start with the premise that you have the Fifth Amendment right to remain silent. Under these exceptions, they can be administratively ordered to answer questions during an administrative investigation. That statement is compelled under the Constitution, which means that it cannot be used in any subsequent criminal proceeding against them. However, that statement can be used for purposes of rendering an administrative decision concerning disciplinary action at Santa Ana PD or any other police department. Now, an officer still has the option of refusing to answer questions. They can then be charged with insubordination because under Lieberger you say, you read through essentially a variety of statements and you say you're hereby ordered to administratively answer my questions. That's a direct order and it's a legal order, so they're obligated to follow it. If they fail to follow it, then they can be disciplined for insubordination and or including up to termination, which is usually the case, quite frankly. Alternatively, if they do continue to exercise their Fifth Amendment right, then you would proceed with add a charge for insubordination. That would be very easy to prove because you've given them a lawful order. They refuse to answer it, then you would go ahead and impose your discipline. Usually on something like this, like I said, the imposition of penalty is termination. So they're no longer a police officer with Santa Ana PD. That being said, they have not given you an answer to any questions that you want to answer them, because why? They're facing criminal charges over here. So they don't really care about what may happen to their job because they're trying to stay out of prison. So they may still exercise that right. Most of the time, when faced with that kind of conundrum, the officers will force their statements to be compelled. They'll answer them. The department is going to do whatever it's going to do administratively. Under California law, that statement cannot be used in the criminal proceeding against them because it's a forced relinquishment of their Fifth Amendment right. So the district attorney's office, for example, let's say they're looking into criminal charges against that officer. They have a right under state law to come over and review that officer's personnel file, including an investigation, so they can come and inspect it. Typically, what they will do is one of two things. Number one, they will say remove any compelled statements from the file, because they cannot use that statement, and that can corrupt their entire charging decision. So they cannot use it. Alternatively, you have what's known as a clean and a dirty team. And it's probably more detail than you wanted to know. The clean team is somebody that does not touch the compelled statement. They don't review it to make a charging decision on whether or not criminal charges should be filed, and it cannot be used against the officer during the trial of that criminal charge if it is filed, because again, it's a forced relinquishment of their Fifth Amendment rights. The dirty team would be a separate investigator and or district attorney in the DA's office who will review the compelled statement. And he or she will stay separate and apart. They will not confer with the prosecuting attorney except in one limited circumstance. That is if the officer takes the stand in that criminal proceeding, then that compelled statement can be used to impeach the officer's testimony if he or she varies from it. So what you'll see sometimes like that is you'll have the clean prosecutor, so to speak, will be doing the case. If that cop gets on the stand and says, hey, I need to tell my story, then he or she is opening themselves up to the DA on the dirty team who knows the contents of the compelled statement, has studied it, much like a deposition transcript, any other piece of evidence, and he or she will then advise the clean team when that officer has stated something contrary to what he or she said in their prior compelled statement, at which time the prosecutor on the clean team can bring that statement in to impeach the testimony of the officer on the stand. So, a little complex. Does that make sense to everybody? All right. I don't know Santa Ana's department. One of the other departments that I represent is LAPD. I will tell you that every statement is compelled at LAPD. I've never seen one that it wasn't compelled. Some other departments, generally speaking, it is an uncompelled statement, and they will give what's known as a voluntary statement, which then can be used for essentially all purposes. So if you give a voluntary statement, you're waiving your Fifth Amendment right, and the DA can rely upon the voluntary statement in making charging decisions and using it as evidence in potential criminal prosecution later on down the road.
A real quick question on that. I would assume it, in a criminal proceeding, it would be hard to get a conviction with those compelled statements. Does it make it more difficult? Because
Well, not really. And the reason being is this. In the vast majority of criminal cases, again, I'm not a criminal practitioner, but from what I understand anecdotally, most of the time the defendant is not going to testify anyway. So you're relying on other extrinsic evidence other than self-incriminating statements of someone refusing to take a stand in trial. So, i.e., I saw the cop do that. Cop doesn't have to say, I did that. You have a witness comes in and say, I saw him punch a handcuffed suspect in the face for no good reason. Okay, use of force outside what is permissible criminally. It would be a battery, so they could be found guilty of violating somebody's rights.
well, in your experience, And assuming there is a criminal act, do most of the officers get convicted of those criminal acts, even though they've given these compelled statements, or is the conviction rate relatively low?
I don't know the answer to that. I haven't followed those statistics, frankly. I can't answer that with any competence.
All right, good enough. Thank you, man.
All right. Next slide kind of discusses a different area here. This goes back to, I mentioned this earlier, subject officers. This is Government Code 3303, subdivision I. Subject officer's right to be represented by a representative of his or her choice, who may be present at all times during the interrogation. Representative shall not be a person subject to the same investigation. So, i.e., you can't bring in a union rep who's also being investigated in the same investigation, because that would undermine the investigation. So that's made clear. They would be kept out. And I want to discuss some of the limitations on this. This is a case, actually, my law firm handled this case. Upland Police Officers Association versus City of Upland. Case from 2003. As noted previously, they have the right to choose their representative of their own choice. In this particular case, there was a limitation placed on that. As I recall the facts of the case, a officer was going to be interrogated. He wanted a specific attorney to represent him during that interrogation. That attorney was first on vacation for a period of time, then was unavailable due to other commitments, work commitments that he had. And so they kept stringing out the interrogation date from when it was originally ordered to take place to accommodate this officer's request to have a certain attorney present. Finally, the department came to the conclusion that we're not going to do this anymore. You are hereby ordered to show up on X date at X time at X location for your interrogation. Well, I can't have my attorney there. Go pick another gunfighter. You're coming in that day, and if you don't, then we're going to deem you insubordinate, and we're going to discipline you for that. So ultimately, the officer showed up with a different attorney, or I think actually the original attorney somehow found a way to show up. It's funny how that happens sometimes. Suddenly they weren't as busy as they quite represented. They went through the interview, and then they raised the issue. They said, this is a POBAR violation. I wanted X attorney. So I think it wasn't the original attorney who showed up. It was someone else from their law firm, as I recall, now that I'm thinking it through. So that I wanted attorney X, and I had to show up with attorney Y. You violated my POBAR rights because I get to pick my own representative, and you didn't accommodate my needs. So we litigated that out. What does subdivision I mean? And ultimately, the court ruled in the favor of the city and said that there's a reasonableness requirement that is built into that. So, i.e., I want Attorney Touchstone, but Attorney Touchstone just went on a sabbatical for 3 months to Tibet to find himself again and cleanse out his body of all mental impurities. And it'd probably take me more than 3 months, frankly, but nevertheless. Sorry, we're not waiting 3 months for Attorney Touchstone to get back. You have to go with somebody else. So the court read a reasonableness requirement into subdivision I, and that is good law to this day. Okay? You will sometimes see some gamesmanship by officers who are subject to an internal affairs investigation. It's rare, but it does occur where especially if they're off duty for some kind of injury or after they get accused of violating policy, suddenly they get injured. Stuff has a way of happening sometimes, and gamesmanship is engaged in this type of stuff. Usually not, but sometimes I get calls about that kind of behavior. So we have to kind of navigate those waters. Now, next slide. This section is talking about POBAR in general. I told you, I gave you that case example, the Labio case, when they're talking about is it really an interrogation under POBAR, or is it this? This section shall not apply to any interrogation of a public safety officer in the normal course of duty counseling, instruction, or informal verbal admonishment by or other routine or unplanned contact with a supervisor or any other public safety officer, nor shall this section apply to an investigation concerned solely and directly with alleged criminal activities. So I mentioned to you earlier, the vast majority of police operations where supervisors questioning, correcting, telling someone, ordering, is not even subject to POBAR. Particularly if it concerns, hey, we're doing a murder investigation here, dude, go collect that evidence. You know, what are you doing? Go knock on that door, see if they saw anything, see if they got a ring video, et cetera, et cetera. So when you're issuing orders like that, or you're asking questions, did you go? I ordered you to go and find the ring video there. Did you go over and talk to them? That is not an interrogation at that point in time, because there's no suspicion that they violated a policy provision. Let's say, okay, you were ordered, which normally that's not going to happen in that context. People are just going to say, all right, hey, we're all here to do a job. You guys go over there and do this, that, and the other. It's not, you are here by order to do X. You know, it's more like a discussion about who's going to do what. And so they come back, and no, I didn't do that. Well, all right, I'm telling you now, go and talk to that person over at that house, see if they have a ring video. Cop then comes back, did you check with them? No, I didn't. Now we've morphed, because first we started with a group discussion, then they come back, they didn't do what they should have been doing, then they are told to go do it, and they still didn't do it. Now we're talking about a potential insubordination issue. So questioning from that point forward, you might start stepping over in the Labio case, versus earlier, when you asked them, did you do it? It could be the same question, but now you've been given an order, it's a different context. But the vast majority of the interactions like I'm talking about here are not even going to be subject to POBAR, okay? POBRA, not applicable to everyday encounters where supervisor questions an officer concerning performance issues. So it's only when it's kind of arising to that level of a potential policy violation, if you continue questioning at that juncture, then you are required to afford the officer POBAR rights, but not until you get to that square. Any questions about that? All right. Section 3304. Protection of rights. No adverse action to be taken because of the lawful exercise of rights granted under this chapter or the exercise of any rights under any existing administrative grievance procedure. In other words, simply because you exercise your POBAR rights, you cannot be retaliated against before that. These are due process rights that are provided by state law to you. Nothing in this section shall preclude a head of an agency from ordering a public safety officer to cooperate with other agencies involved in criminal investigations. If an officer fails to comply with such order, the agency may officially charge him or her with insubordination. So you have neighboring jurisdiction that's doing a criminal investigation, and you have some pertinent evidence, or maybe there's evidence and/or witnesses in your jurisdiction versus neighboring jurisdiction. You can be ordered to assist that other jurisdiction in the criminal investigation. That does not implicate POBAR as far as that order. Very different from your LIBAR order, where if you do violate that, you can be subject to disciplinary action for insubordination. Well, indeed, if you violate either order. This is saying they can give you that lawful order. In other words, and if you fail to comply with it, you can be insubordinate. Right to administrative appeal. We've kind of been talking around this a little bit all night, so here's the formal section which puts us into state law. Section 3304, subdivision B as in boy, no punitive action or denial of promotion on grounds other than merit shall be undertaken by any public agency against a public safety officer who has successfully completed the probationary period that may be required by his or her employment agency without providing the public safety officer with an opportunity for an administrative appeal. So what does that mean? Let's break that down. Typically, you have an officer who is hired. They are then sent through the academy at the city's expense. When they come back, they're going to be a peace officer with your agency. When they get back to the agency, so they go through the police academy where we talk about all those learning domains I've been beating you guys up with over the last couple of sessions. Then they come to the department, and then they're trained by the department Through a probationary period, they're going to go through field officer training, okay? And then they'll have a FTO, field training officer, or multiple ones usually during different rotations and different periods, training periods, where they're going to learn, they're going to take the 30,000-foot level stuff that they get in the academy. Now they're going to have that reinforced on practical street procedures, learn Santa Ana Police Department policies, become familiarized with them. They're going to be tested throughout this provision, how to properly search someone, take somebody in custody, everything about policing. They're going to go through that probationary period. Sometimes an officer's probationary period can be extended if they're having some difficulty passing certain milestones, however it's set up. While that officer is on probation, these POBAR rights have not vested. Okay? So, all this stuff about administrative appeals and everything we've been talking about, they don't have yet because they're not a full-time vested employee. They're still on probation. So you can be released from probation for no reason at all. You failed to meet the standards of Santa Ana Police Department as a peace officer. We're hereby releasing from your probationary employment position with us. Have a good day, have a good life. And then they can go about everyone else. They don't get all these rights. You don't have to interrogate them, et cetera, et cetera. I will tell you that even in probationary issues, because there are the release of probationary employees, because there are potential litigation issues, there's sometimes an investigation that goes along with that, so that you're gathering evidence, getting witness statements, and so forth. But they are not entitled to that. All right? Once they are off probation, they're a full-time peace officer with the Santa Ana Police Department or any other police department, then POBAR kicks in, and they have all those interrogation, administrative appeal rights, and so forth. The scope and conditions of those administrative appeals are governed by terms set forth in your municipal code, your MOU with the police union, et cetera, et cetera. And those vary from jurisdiction to jurisdiction. Even though state law doesn't require it, I have seen jurisdictions who have put in their personnel rules the right for full-blown POBAR rights for a probationary employee who is going to be released from probation. I don't think that's wise because I think that complicates your decision-making process. That being said, this is the minimum of what you have to do. You can always provide more rights if you choose to do so. But that's how it plays out. And those administrative appeals, like I said, they can take the path that we just discussed earlier. Binding arbitration, arbitrator, personnel board, you name it. There's a variety of different structures associated with that. Now, there is a statute of limitations that's set forth in POBAR 2. No punitive action nor denial of promotion on grounds other than merit shall be undertaken if the investigation of the allegation is not completed within 1 year of the public agency's discovery by a person authorized to initiate an investigation of the allegation of an act, omission, or other misconduct. So, once a person who is in a position to instigate an internal affairs investigation becomes aware of allegations of misconduct, the statute of limitations begins running. From that point forward, you have 1 year to complete the investigation and issue your notice of intended discipline. The actual discipline itself does not have to be completed within that 1 year period, however, okay? And there are what I call clock stoppers, where you toll the statute of limitations. In the event that the public agency determines that discipline may be taken, it shall complete its investigation and notify the public safety officer of its proposed discipline. Again, this is part of 3304. Proposed discipline by letter of intent or notice of adverse action, they're called various things in various jurisdictions, articulating the discipline within that year. The public agency shall not be required to impose the discipline within that 1 year period.
I have a question on that.
Yes.
Are there any consequences if, for example, that the completion is intentionally not completed, right? Like, let's say the person is really close to whoever's doing the investigation, and therefore they don't complete the investigation within the year. Like, what are the consequences? I know there's no consequences to the officer, right, because they have the right, but I'm saying, are there any legal consequences?
So
For the
you're
person-
saying,
The person who's conducting the investigation intentionally does not complete it within a year, so
Mm-hmm.
that there's no further investigation.
I've never seen that occur. It could occur. So typically, a couple of things happen. There are checks and balances in place. Usually, the chief is not going out and doing the investigation. Typically you have a internal affairs or professional standards bureau sergeant or lieutenant, or you'll have an outside investigator in some instances, who is going to be doing the investigation and gathering all the facts and evidence together, and then making essentially a determination, whether by preponderance of evidence, that those policy violations sustain, not sustain, this and the other. That then goes to the next level. It may go to a captain, who then makes a recommendation after reviewing the report, the evidence of what he or she thinks the proposed discipline should be. Then that goes to the chief. The chief then is going to look at it. He's free to modify it. And then once they finally get to arrive at the final verbiage of the notice of intended discipline, then it would get sent to the officer. They have that ability to do the Skelly conference and then notice of final discipline. So my point in describing that process, again, reiterating it, is it would essentially take the chief being dilatory in his or her duties for that scenario to happen. Because the sergeant who's really tasked with doing the meat of the investigation would have to be deficient in his or her duties. And there's going to be some people who are overseeing, supervising that sergeant saying, hey man, get it done. We got a month, get it done. I want it on my desk in 2 weeks. Or ultimately the chief, depending on the department, they may have a list of pending investigations, completion dates, it may be all charted out. The chief may come down, if that captain or lieutenant's not saying something, and say, hey, I note that our investigation needs to be completed by X and such date, get it done. So it would really take a failure up that chain of command. Intentional failure, I have not seen that happen. What I have seen happen is through essentially negligent action. There weren't appropriate checks and balances, there weren't appropriate oversight of things, where an investigation did not get completed within the appropriate time period, or that rarely happens. Or alternatively, there was a misperception about when the statute of limitations began, so people thought they had more time, and then some clever esquire later on said, you should have, this is when you first knew about it, on this date, not this date, when you thought everything started. So you messed up, and then they'll have the decision reversed. That happens more common than anything, in my experience. It's just a misunderstanding of when things started.
But I would think, and correct me if I'm wrong, that in the event that hypothetical did occur where somebody did intentionally delay to blow the statute of limitations, that individual would be subject to obviously administrative discipline, civil liability, and potentially even criminal liability.
So you're obligated under state law to investigate these allegations. Certainly, I think there would be, I can't think of well, take that back. There is a government code provision that says if you fail to complete a mandatory duty that you have under the law, then you can be guilty of a misdemeanor. I've never heard of it actually being utilized and prosecuted in anyone, but that's a potentiality. Certainly administratively, if a chief were doing that, he or she would probably be terminated. Because like I said, the buck stops with the chief. And the city manager and or city council would probably direct his or her firing if they had any suspicion that something like that was going on. But that would take failure at multiple levels.
So in other words, there would be a follow-up as to why the statute of limitations was reached, and they'll start investigating what happened. Why is it that a year went by and we weren't able to get to a conclusion? Oh, because this guy kept asking for that one attorney for 3 months, and nobody pressured him to find one.
Yeah.
So it would be looked at.
Potentially, yeah. If a situation like that occurred, then somebody's gonna be asking some questions. Like,
And you're
Chief,
si-
what's going on here? Why wasn't that done?
And you're saying that this rarely happens where
I've never heard of that.
investigations just pass the statute of limitation?
Oh, no, that does happen. Usually it's a misunderstanding of when the statute began running or something of that effect. I've seen that occur. Although even that's pretty rare. I've never heard of a situation where there was even a specter of an allegation that someone intentionally did that. Look, you're putting your own ticket to practice on the line by doing something like that. I don't know of too many law enforcement officers who are going to jeopardize their own career. Is it possible? Sure. I've not seen it happen, but that doesn't mean there might not be an example out there I'm unaware of. Usually, like I said, it's typically a misunderstanding of the law as far as when the statute began running. And even that is fairly rare. Most departments are knocking things out. I think that people shoot for about 9 months. So it's very clear when a statute starts running when you get a citizen's complaint. Because you have an allegation, it has to go through the proper channels. It's going to be vectored to your Internal Affairs Division, which has the authority to initiate internal affairs investigations. Usually, obviously, they're reporting up the chain of command. We have this chief or LT, lieutenant, captain, whatever. I don't know how you're structured exactly. They're reporting it up the chain of command, what they're doing. We got this in when we're going to begin the investigation. You open an IA file, you assign it a number, you assign investigators to it, and you go through that process. Sometimes it's not so clear. So let's say one patrol officer sees another patrol officer doing something that is wrong. That patrol officer who observes this other officer is not authorized pursuant to internal department policies to initiate an IA. Now, they may have an obligation to report misconduct, but they have no authority to initiate the IAs to this officer, okay? They wait. Finally, the guilt gets the best of them. They go to internal affairs and they report it as they should have done. So the question then becomes, when does that statute of limitations start running? From the date of the officer's actual misconduct or the discovery by the IA division of that misconduct? The answer is the latter. It starts running when people who can initiate the internal affairs investigation get knowledge of it. And now, in that situation, Officer 2, the reporting officer, is probably also going to be subject to discipline for waiting X number of months to report potential misconduct. So there'll be a second IA opened as to that officer and the delay in reporting the misconduct, and that'll be investigated as well.
Okay, so
Potentially.
in the context of a department that's understaffed and there's several investigations that just pop up, they're able to say, look, we don't have the staff to look into everything. We're going to wait to investigate this thing. So the statute of limitations hasn't started yet for that case until they start looking into it, right?
No, that's oversimplification. First off, the defense of we don't have the resources never flies. The Constitution doesn't have a price tag on it, nor does compliance with mandated state law. So simply saying I don't have the resources is never an answer that's accepted. Find the resources. Take cops off the street if you have to, because these are statutory obligations versus discretionary patrol things. Second off, it only starts running when people who can initiate that investigation find out about it. Okay, so at that point in time. So them saying, okay, when they get knowledge of it, if they then wait, it still starts running here, regardless of their actions or inactions downstream. So, which I think is the thrust of your question. In other words, once they get knowledge, whether or not they actually start doing anything to actually investigate, that's not when it starts. It starts back here. And that's where people sometimes get caught up. Frankly, there is the misunderstanding, or there may be resources issues. This is a real answer as to why some of these things don't get completed in a timely manner. But that's not an excuse. You can't go to the judge and say, well, hey, you should open more time up, because we've got 5 sworn officers and I've got 1 investigator and he only comes in every second Friday of the month. Not my problem. Your problem. All right?
A quick question on the
Yes, sir.
statute of limitations. Again, I saw something happen 5 years ago, and I finally gets the best of me, and I report it. Not an issue, correct?
Not an issue.
Thank you.
No, and in fact, I can give you a couple of case examples on that. In fact, one of them I was involved in litigating. We did an amicus brief for the city of San Francisco. It's called the Doherty decision. In that case, there were two investigations that were running parallel. There was a criminal investigation that was being run by the United States Department of Justice into extortion ring by San Francisco Police Department officers that they believed was potentially occurring. And that investigation went on for a number of years. During the course of that investigation, they had an administrative investigation that was also running concurrent with. However, the Internal Affairs Criminal Division, San Francisco is a large department, so they had what's called IA Admin and IA Crim. IA Crim would ultimately take their findings and present it for the criminal charges. So they were working with the US DOJ investigators and the FBI. They had to sign a confidentiality agreement saying everything that they gathered during the course and scope of their investigation, they would not share outside of this team. There were wiretaps, there were subpoenas for text messages and so forth. And in fact, they discovered a whole group of officers who were texting back and forth racial slurs, homophobic slurs, all things which were violations of departmental policy. They were not, however, crimes, other than the crime of being stupid. Which unfortunately too many are guilty of these days, myself included sometimes. So they had that information, but they couldn't share it with IA Admin, who was entitled to do an administrative investigation. When they concluded that and they actually got a conviction of a couple of cops for engaging in criminal activity, they turned that evidence over to IA Admin. So the question was, because a lieutenant, it was rank of lieutenant who's normally a supervisor who can typically order an administrative investigation, when IA Crim lieutenant found out about it, did the statute of limitations start there? Or did it start over here when IA Admin found out about it? My argument was here, because these are the people who do administrative investigations. And ultimately, the court agreed with that argument. So they then went forward with the investigations for the policy violations for engaging in all those, terrible text messages that were being exchanged. And ultimately, those officers were disciplined. To illustrate the point for you, if that helps. All right. Now, clock stoppers. So you normally have 1 year from the time, like I said, somebody finds out about it until the time that you complete your investigation and arrive at your final disciplinary decision. You don't have to do the discipline within that 1 year, but you have to get to that final disciplinary decision. Clock stoppers for statute of limitations, 3304 subdivision D2. A, if this is what you will toll the statute of limitations. If the act or omission or other allegation of misconduct is also the subject of a criminal investigation or criminal prosecution, the time during which a criminal investigation or criminal prosecution is pending shall toll the 1 year time period. So you can be aware of it, you can open the IA, toll it. Wait for the criminal prosecution to conclude. If the officer is convicted of a crime, then you untoll it and it makes your decision on the administrative aspect very easy. Certainly if it's a felony under Government Code 1029, they can no longer be a peace officer in California. You can terminate them based on this criminal finding, which is beyond a reasonable doubt, which is higher than your preponderance of evidence standard. So that's the easy way. Alternatively, you can proceed forward, and depending, as the chief mentioned earlier, depending on the nature of it, you may be put on admin pay with leave, you may be put on admin pay without leave because of the nature, how high of a level of violation. If you are indicted, there's a case that says you can essentially terminate someone immediately, even though they don't have the full protection. You get them off duty without pay immediately. So there's a variety of things that can occur there, but that's one thing. You can stop it, wait to make your job easier until the conclusion of the criminal prosecution. Alternatively, if the public safety officer waives a 1 year time period in writing, the time period should be told for the time specified in the written waiver. I've never seen that done, or it probably is a case, but I've never seen it done. If the investigation is multi-jurisdictional investigation that requires a reasonable extension for coordination of the involved agencies, that is a very murky, ambiguous tolling provision to rely upon. I generally advise people do not rely upon that, get it done, because that is very subject to interpretation. If the investigation involves more than one employee and requires a reasonable extension, again, that can be very murky. I generally recommend get it done. If the investigation involves an employee who is incapacitated or otherwise unavailable, in this, you have some gamesmanship that is sometimes played. Like I said, sometimes, unfortunately, an officer gets accused of misconduct violation. He or she then suddenly becomes injured and goes injured on duty, IOD, where they're at home getting paid, and seeking medical treatment, this, that, and the other, going to see a physician, et cetera, et cetera. And you say, well, hey, we still have the IA, we need you to come in, do the interview. I'd love to, but my back hurts, I can't sit down. That's all right, we'll accommodate you, we'll let you stand every 10, 15 minutes, do whatever you need to do. We'll come to your house and interview you so you can stay in your orthopedic reclining chair. Sometimes that gamesmanship goes back and forth, so. But again, incapacitated can have a variety of meanings. Obviously, if somebody is in a coma, clear, they are completely and totally incapacitated, and I think you could effectively invoke this tolling provision. But otherwise, I always get a little bit wary of that because there's no definitive start and stop time, and that's where you get murky on getting that thing done on time. Subdivision F, if the investigation involves a matter in civil litigation where the public safety officer is named as a party defendant, the 1-year time period shall be tolled while that civil action is pending. This is used pretty frequently. If there's a civil rights case against a particular officer, and there's a parallel, sometimes the departments will toll it because you don't want to have kind of two parallel proceedings in that case versus criminal, and they have the option to control that. If the investigation involves a matter in criminal litigation where the complainant is a criminal defendant, so now we're not talking about the cop, we're talking about the complaining party is a criminal defendant, the 1-year time period shall be told during the period of that defendant's criminal investigation and prosecution. I have seen the complaint process be used strategically by criminal defendants to attempt to have an officer who is going to testify against him or her discredited by way of a policy violation or just make their life difficult. So sometimes departments will invoke this tolling provision. H, if the investigation involves an allegation of workers' compensation fraud on the part of the public safety officer, that is sometimes done as well. Although, again, if it's workers' compensation fraud, that's criminal and has a whole different set of potential problems. Reopening so those are the clock stoppers, if you will. Reopening an investigation after the 1-year statute has passed. It can be reopened if both of the following circumstances, so we're talking about the conjunction of and here. Significant new evidence has been discovered that is likely to affect the outcome of the investigation. And we're talking about significant new evidence which reasonably could not have been determined had an effective investigation occurred in the first place. And there's an and in between there too. One of the following conditions exists. The evidence could not reasonably have been discovered in the normal course of investigation without resorting to extraordinary measures by the agency, i.e. flying to Tahiti to interview that one key witness that they just found out about. Or 2, the evidence resulted from the public safety officer's pre-disciplinary response or procedure. This is what I was talking with you about earlier about the Skelly hearing. So you've kind of got to that decision and the officer comes in and says, listen, I didn't do it. You need to talk to this witness. So if that 1-year period is already done, then you can reopen the investigation if you have new information that was disclosed to you during that Skelly conference and reinvestigate it and potentially come to a different conclusion. Okay? 3305. Adverse comment in personnel file. No public safety officer shall have any comment adverse to his or her interest entered in his personnel file or any other file used for any personnel purposes without the public safety officer having first read and signed the instrument containing the adverse comment indicating he is aware of such comment. This is designed to prevent supervisors from keeping so-called secret books on officers. If they have an issue with their performance and they're putting an adverse comment in their personnel file, then they are obligated by law to show it to that officer, have him or her sign it, and then place it in their personnel file, which then leads us to the next provision. From the time that officer signs it, he or she shall have 30 days within which to file a written response to any adverse comment entered into his personnel file. Such written response shall be attached to and shall accompany the adverse comment. So anyone who's going to go in and read the adverse comments put in the personnel file also has, right to the back of it, the officer's response. This is not appropriate, and here's why. I should not have had an adverse comment put in my file. Okay? It's particularly important if someone is leaving to go to another agency to work and they come and do a background investigation. Kind of helps explain it.
Real quick on that, can
Yes, sir.
the officer get that removed?
Get the,
Adverse comment removed?
under certain circumstances, yes. It's kind of beyond the scope of this. You know, we would go down a rabbit hole there, usually involving an administrative appeal and all kinds of stuff like that. But yes, it can potentially happen. 3305.5, this is one of the more recent additions to POBAR. A punitive action or denial of promotion on grounds other than merit shall not be undertaken by a public agency against any public safety officer solely because that officer's name has been placed on a Brady list or that officer's name may otherwise be subject to disclosure pursuant to Brady v. Maryland. So, in other words, you cannot simply terminate somebody because they're put on a Brady list and they can no longer effectively be a cop on the street. It's a two-part process now. And there are certain, the mere fact that someone's on a Brady list is not sufficient to terminate somebody's employment. You kind of have a bifurcated proceeding for disciplinary actions, if that's one of the things that is at issue. And I don't want to go through all the procedure with that.
What's the Brady list?
Oh, I presume too much. Brady v. Maryland is the United States Supreme Court case, and essentially, pursuant to that, there is a obligation of the prosecutorial team, which includes the district attorney and investigating officers, law enforcement officers, to disclose any type of things which could potentially materially affect the outcome of the prosecution. So, for example, if a officer has been found guilty of, guilty is the wrong word, if they've been found to have lied in a misconduct investigation, number one, they're probably not going to be a cop anymore. But number two, that would have to be disclosed, assuming they still were a cop and they were a witness to a crime who's going to testify in the case. If an officer has exhibited racial bias or animosity against a person, they can be placed on the Brady list because they're now have a demonstrated bias against a certain racial group, and that can materially affect the outcome. Say, for example, an officer made a comment that indicates he is biased against African Americans, and the criminal defendant in a case happens to be African American, then the prosecution is obligated to disclose that. If they do not disclose it, then that conviction against that African American suspect can be reversed. And in fact, there could be repercussions to the DA's office, even if the disclosure, certainly if it was an intentional act, there could be severe repercussions. Even if it was inadvertent, however, the DA didn't know about it. If a member of the prosecutorial team was aware of it and it was not disclosed, then the conviction can be reversed. That doesn't mean it goes away. They have to be retried without that evidence on different things. But essentially, it's a due process concern, is if you become aware of anything, separate and apart of your disclosure obligations under California state law, anything that could be deemed Brady material. And there's a wide variety of misconduct. The most common one being untruthfulness or racial bias are the most common ones that I typically see. So you have an obligation to disclose that evidence, even if it's not sustained. Even if it's not sustained sometimes. Brady is broader than what's called pitches motion rights. A pitches motion is a motion that normally you have to file in state court to get access to a particular officer's personnel file and allegations that are similar in nature to what may constitute a material defense in a claim before the court. I'm sorry, I'm going down procedural rabbit holes. This is complex stuff, folks. I'm trying to make it as simple as I possibly can.
Can you please turn on your mic?
Hello. This Brady versus Maryland, is that Brady from the Reagan era, who was shot while they were going to their limousine?
I think it might be. Candidly, I haven't read that case in forever because I'm not a criminal prosecutor, so
It's all the papers.
none of this stuff applies to me. But I haven't read the case in a bit, but that sounds familiar.
Especially coming from Maryland, too. That's where it happened.
Yeah, so 1963,
That's
is that
about
about the
right.
time frame? Yeah, good chance that's correct.
So this is saying that if they're on the Brady list, that can't be used against an officer when it comes to like promotions and stuff like that.
That's not exactly correct. You cannot terminate them solely based on, or deny them, you can't discipline them solely based on the fact that they're placed on the Brady list. There has to be something in addition to that, and it's a bifurcated procedure. I'll get the provisions if you would like me to at our next session and kind of go through how that plays out.
Yeah, I was just wondering what the point of being on a Brady list is. If
Well, so if you're on a Brady list, many times a prosecutor, if a officer who is on a Brady list, and by the way, the DA, the prosecutors put officers on and off Brady list. Frankly, I think there's serious due process violations associated with that because their appeal is to the DA who put them on the Brady list. So think about that for a moment. I'm the judge. My appeal is to me. Yeah, I think I got it right the first time. Thanks for coming. So I personally, I don't think that complies with due process, and I'm waiting for a case to withhold. There should be some judicial review, much like when the chief makes a decision on placing someone on terminating them or disciplining them. That person is entitled to review. Someone gets convicted of a crime, that person gets an appeal, right? Under the way that currently the Brady cases are structured, DA has essentially sole discretion, which makes no sense to me. But I'm waiting for a case to say otherwise.
I've got a question on the Brady list. Is it national?
No,
or is
typically,
it regional, and who maintains it, holds it?
normally it's maintained by the county's district attorney's office.
And
So-
that's only with the input from the police departments?
Not necessarily.
How do you get on the Brady list?
You can get on the Brady list a variety of ways. It could be because somebody has been disciplined for a certain amount of thing, a certain type of violation. Alternatively, there could be allegations by another party that someone has lied in an investigation. Usually those, generally speaking, need to be proven in some fashion versus a bare allegation. There could be a myriad of different ways. It can vector in, but the DA creates the Brady list, maintains it, and they can place an officer on it without any input from the department. In fact, I've seen that many times. I've written responsive letters on behalf of officers who were placed on a Brady list and saying, there was an allegation that you did X, Y, and Z in this particular case. There was no IA associated with it. There was no sustained finding of that officer actually doing that. I'm like, well, hey, an allegation is not proven. Again, this is my concerns about the whole Brady list process. I think there are serious due process concerns about it.
So in essence, somebody could put into the portal a complaint against an officer because of whatever reason, and it ends up on the Brady list.
Potentially, yes.
Okay, thank you.
Usually there has to be some indicia of reliable information and evidence behind it,
Yeah,
even
let's-
if it's not a finding per se.
No, I understand,
Yeah.
but you see what I'm saying? Somebody files a complaint, and they list the officer's name, time, date, they did this, that, and the other thing, and then it's possible it can end up on the Brady list, the officer.
I will tell you from my own experience, there are people who file hundreds of citizens' complaints monthly. Same person who's had no police contact during that month, but they file hundreds of citizens' complaints. There are processes in place that have good underlying, goals that sometimes get abused. And sometimes without any significant repercussions. In fact, there's a case pending in front of the California Supreme Court right now on filing false complaints against police officers. And it's been pending there for several years and we don't have a decision yet.
And to tie in with that, does the officer know they're on the Brady list? Is there any notification?
Yes, they get notified.
Oh, okay.
And
So
is that list public? Is that list public?
I don't believe it is. I don't think so. No, the DA maintains it. Yeah.
And you said it's hard for the officer to get removed from that, or is it's relatively difficult because
Yeah, so there's no procedural by way of a court action to get removed of it that I'm aware of. That's what I'm waiting to be established by some case saying that you need to do that. However, district attorney's offices, many of them, not all, but many, and I believe Orange County DA, have a internal administrative appellate procedure. So usually somebody in the DA's office says, I recommend we put Officer X on the Brady list. That decision typically goes to the DA to confirm it based on his or her review of the evidence that they believe supports putting him on the Brady list. The officer is then notified, you're on the Brady list, or the department is notified, or both. Usually both, by the way. And then the officer has that internal, they make up the appellate scheme, saying you can come and present X amount of evidence to us, and here's who you contact, and this, that, and the other. And ultimately, that decision goes back to the DA as to whether he or she will reconsider their decision. And then they can potentially get removed from the list, or potentially not.
Yeah, thank you, I appreciate that.
And it can significantly impair an officer's career, because essentially, what the DA will not use them as a witness. They're effectively, their careers as a patrol officer are ended for the most part. So they have to be reassigned to something where they're not having interactions with that could lead to criminal prosecutions. So it's been somewhat ameliorated now from the advent of body-worn cameras. So it's not just a he said, she said. So now sometimes DAs will even file a case even if the officer is on the Brady list, if they have good body-worn camera footage that captures the entire encounter, to demonstrate that this officer, what they said in their report, is actually factually accurate through objective evidence. Frankly, 10 years ago, being put on a Brady list was the death knell for an officer's career. Less so now. Less so now with a lot of these things I've been discussing.
But to your point, very damaging and very tough to get off.
Yes.
Thank you.
Less and less so damaging, but it's not a good place to be. You're on double secret probation, so not so secret. All right. Inspection of personnel files. I'm going to hit this real quick. Every employer at reasonable times and reasonable intervals upon the request of the officer during usual business hours with no loss of compensation shall permit the officer to inspect their own personnel files. Again, subject to reasonableness requirements. It's not in there, but that is certainly the case. You can't go in and spend 2 hours of every shift checking out your P file. Just wasting time. Polygraphs, 3307 of the Government Code. No public safety officer shall be compelled to submit to a lie detector test against his or her will. No disciplinary action or other recrimination shall be taken against a peace officer refusing to submit to a lie detector test, nor shall any comment be entered anywhere in the investigator's notes or anywhere else in the public safety officer's file if they refuse to take or did not take a lie detector test. Now, I will tell you that some departments do require if the officer seeks to be voluntarily assigned to a particularly sensitive position, they do sometimes require a lie detector test. That's rare, but it does happen sometimes. And they're essentially relinquishing their POBAR rights because they want it to be assigned to a special assignment. That has been found to be permissible. But your average officer can't ask them to do a polygraph and can't discipline for failure to do so. The slide you wanted to see all night, folks. Questions? All right. Hit you with a lot tonight. Thank you for your indulgence of your time. Hopefully it made some sense.
Thank you,
Again,
Mr.
scratching the
Touchstone.
surface
Appreciate it.
on a lot of this, but hopefully that gives you at least some guardrails for decision-making. Okay,
Do commissioners have questions for Mr. Touchstone?
Thank you very much.
happy to help. Happy to help. Thank you.
No? To my left? No? Okay. Do we have additional training with you moving forward, or was this the last?
Nothing has been scheduled to my knowledge, but I don't know if Jonathan was planning
Okay.
on contacting me again, or you're going to get the pleasure of hearing someone else speak.
Okay, well, I want to thank you so much for that training,
Yeah,
and
happy to
thorough
help.
training, Mr. Touchstone. Appreciate
Thank you
it.
for your attention.
All right, so that concludes our training for today, and we're moving on to comments, staff comments. Is there anyone that wants to make staff?
Yes, I'm going to be very brief. Couple things I wanted to touch on. Currently, City Attorney's Office is working with staff from PD. We are assembling a lot of the statistics that this body has asked for. A lot of these things didn't just come in, thank you, Jane. A lot of these things did not just come in prepackaged form, so again, we're working on putting those together, and we should have some available at the next meeting. I believe, Chair Vega, you brought this up last time. I plan on, I don't know if I'm gonna bring hard copies or just email copies of current lawsuits that would probably fit under the parameters of the ordinance and what it envisioned in terms of disclosure of lawsuits. There's also employment, there's employment matters that may not be classified under the misconduct that this body would even be able to consider. So there's kind of a little sifting on those. Last point is, I believe Mr. Soto brought this up at the last meeting. The complaint portal has been up and running for at least a month now, maybe over a month. We've not received any complaints yet. To the extent that we do, the complaints will be routed directly to me, to Mr. Soto, and to Commander Lopez here. So there are gonna be 3 sets of eyes that will see any complaints come in, and then from that process, we'll work out how we're going to actually present those complaints to this body. I would remind the body that if the complaints involve a particular officer by name, and it is involving the items of misconduct that are envisioned within the ordinance, that any discussion about those would have to occur in closed session. The ordinance is pretty clear about that point. So when that happens, when a complaint comes in, we'll definitely set up a process by which we can review that as a commission. And, Deputy Chief, I wanted, would you just speak just very briefly about the use of force, the training simulator? Maybe scheduling some times.
Yeah, I mean, the only, we could really do the entire group, but because of the Brown Act, we gotta
Right.
break everyone up. So we could break it up in 2, 2, and 2, or 2, 2, and 3, I'm sorry, because we're missing one tonight, but, and to be able to accommodate, those training needs. That training is really essential. I'd like to do that at the end of your guys' kind of school training session, so that you kind of have a lot of the policies, procedures in your mind as you're now dealing with and interacting with the virtual screens and dealing with the scenarios that our officers do have to deal with quite often out on the street, so that you get a good understanding of what it's like to not just learn academically what the policy says, but now you have to actually demonstrate it in practice in these fast-changing scenarios. Some are pretty easy, some are pretty tough. Our training staff will, obviously they can, by the click of a button, change the way the scenario goes based on how you're interacting with the characters. But I would highly recommend doing that. And we can discuss a time for whenever, whatever works for you folks. And like I said, probably 2, 2, and 3 would be a good mix, so that we don't have any issues with the Brown Act. And we can do several days, or we can even break it up for, hour increments, or, whatever time blocks, so that we can get everyone through. Because again, I think it is very worthwhile for you to apply the training that you've received.
And that particular training, does that have to be public?
No, that would not be a meeting, because there will not be a quorum. It's going to be we're gonna do two, and three. So there's not a quorum, it would not be a meeting, it's just three or two of the commissioners appearing at the PD to run through that training. I should say, and I'm kind of piggybacking off what the one speaker, the gentleman we had this evening, I correct me if I'm wrong, I do believe that he mentioned mandatory ride-alongs. The ride-alongs have never been mandatory. They've never been a requirement to sit on this commission. It was just something that was offered to the commissioners in the event they elected to do so. The same is true of this particular training. I will say that this is a very, I think it's very desirable to try and go through some of this training at the PD regarding the use of force simulator. Many people will never have access to that sort of simulator. I've never been through it. I know I'm gonna go. And so I think that it would be worthwhile, really worthwhile for all the commissioners to attend that and just see what it's all about. But again, much like the ride-alongs, it's not mandatory. It's not set forth in the code that you have to do it, but I would really encourage it.
Would there be a possibility if one of us were to volunteer to be videotaped doing it just so the public can see for themselves, what that training is like?
I'd have to talk it over with our legal team, the police legal advisor, just to make sure there's no issues.
Sure.
I don't foresee any problems with that. That might actually be a good idea. In fact, I think we've had news folks come through and do the training, so it's probably not a problem. Just let me confirm with our police legal advisor.
Okay, because I think that would be a great video kind of showing the commission going through this training and kind of make the public aware of us as the body and what we're doing, and I think that would be good.
I agree. No, I think that would be good, and I think you guys would get a lot of benefit out of it, and you get a lot of laughs out of it as well, because it is quite fun to go through that training.
Has the complaint link been promoted publicly, or has it been a flyer publicly on social media or anything like that?
I do not know the answer to that question, Commissioner. I know that Mr. Soto was the one who worked on the link and has it published. I can share that link with all of you, and I would encourage all of you to promote it via your own social media, via community meetings that you may want to hold. I will also speak with Daniel Soto about ways that he can, for lack of a better term, advertise and kind of promote and get it out there in the community. But I will share the link with all of you via email. There's absolutely no reason why each and every single one of you cannot put that out through your own channels and forums so that it just gets greater exposure in the community.
I would even say that it would be great if the police department social media put that link forward themselves.
Absolutely. We could commit to do that, and we also have our own link on our own website advertising how to file complaints. So filing or using your link and essentially advertising for that avenue is not a problem.
Yeah, make a video of somebody saying, hey, if you guys have a complaint, something that we did wrong, we encourage you guys to follow this link. And I think that would be very powerful, showing that to the public and coming from you guys.
Okay. Thank you.
If I could request for that, yeah, I agree. But if that could be also in English, Spanish, Vietnamese, yeah, just the same way that the city Santa Ana pushes out its Facebook messages.
A real quick question. You still have the old intake forms available for people that are not internet savvy and social media and all that kind of stuff?
You're talking about
The complaint forms.
Yeah, we still have those
Okay.
available. People can download those online as well.
Yeah, I'm just, some people don't have that access and don't do those kind of things. That's why I'm asking if that's still available and will continue to be available.
Absolutely. We aren't looking to diminish the ways we accept complaints.
And to tie in with that, have we received any paper forms?
Not that I'm aware of.
Okay,
Yeah.
thank you.
I have a question. In terms of the link, I know on the ordinance it says that complaints can be filed retroactive. I don't know what that date establishment is, though? Is that the date that all of us were sworn in, the first day we had our meeting? I've had someone ask me that they want to file, but they're not sure whether the date is valid.
Yes, thank you for that question, Commissioner. And I think this came up previously with Chair Vega. I've looked into the ordinance. The plain language of the ordinance is that the complaints must be filed within a year of the alleged misconduct. So I understand that there is concern about the time it took for various commissioners to be appointed, and by the time that this commission got started, where we're at now. I understand those concerns and I hear them. Unfortunately, there is no tolling provision provided in the ordinance. So it is 1 year from the date of the alleged misconduct. Now, that doesn't mean that council could not go back and amend that if they wanted to create some sort of retroactivity that goes even further back. But I think one point, and I'm not going to speak for Mr. Touchstone completely, but one point that he really got on was the statute of limitations under POBAR, the 1 year. And while I did not craft this ordinance, I think that was sort of envisioned with the 1 year, statute of limitations we built into our ordinance. And again, I don't want to speak for the framers of our ordinance, but it seems to kind of match up. If under POBAR, you only get 1 year, it would seem that under our ordinance, you would only get 1 year as well. It makes sense that those two timeframes align.
Real quick, just to kind of dovetail on that, there's nothing to prevent you from filing a complaint and having it go through the system as it is, regardless of this body. And the result could ultimately be the same, correct?
Correct, yeah, we're mandated by state law to actually accept and investigate all complaints. So anything that comes to us, it doesn't change. We will continue to investigate as we normally do.
Thank you.
Staff, any more comments?
None from me, thank you.
All right. Commissioners, any closing comments? I'll start to my right.
Yeah, just thank you guys. The training's been great, enlightening to say the least, and I appreciate it. And I hope to see you guys in the field again here real soon. And thank you again.
Commissioners to my left.
No comments, Ray.
No, thank you. But thank you, everyone, for putting this together.
Yeah, I just want to say the same thing. Thank you so much for everything that you guys have been doing. Really appreciate it. So with no further matters to discuss.
One last thing, I apologize, Chair. I just wanted to give a little preview of what's to come. Obviously, training with Nicole, that's been discussed. Thanks to Commissioner Mejia, I have been in contact with a staff attorney from the ACLU with regard to their co-sponsorship of AB 392, and they would like to have some input and a word with regard to their interpretation, and I'm more than happy to accommodate them, so that's to come. And this next week, you're going to see use of force presentation from our own PD. So again, holistic, robust. You've heard use of force from Mr. Touchstone. You're going to hear use of force from RPD. You're going to hear use of force from ACLU with regard to AB 392. And NACOL will touch on use of force, although please understand that NACOL is a national organization, so that will probably be a little more broader strokes. But we are dedicated to really honing in on the use of force issue because we understand that is probably one of the hottest topics and one of the obviously most controversial and one of the most important to address. So we want to make sure that you're getting a very, very comprehensive look at that issue from multiple subject matter experts. Sorry, and that's
No worries. Thank you for that. And just one clarifying question. To add things to the agenda, we email you, or who are we supposed to email?
You can email me, and I will have items added to the agenda. Part of what was going to happen when the independent oversight director was selected is that I am going to work with this individual in creating bylaws, because this committee needs bylaws. And they will be crafted from, you know, we're not gonna reinvent the wheel. They will likely be crafted from other commissions' bylaws, but also tailored to what the ordinance requires. Because the ordinance has specific rules set forth, and those things will merge, but I want the input of the independent oversight director. And those bylaws will have the formal process for adding items. At this time, you can go ahead and email me. I just have to say, I can't, if each of you were to email me 2 or 3 items, I can't put all of those items. So there's gonna have to be a little discretion on my part and some communication back and forth about vetting and being realistic with the time constraints that we have, and the fact that we're still undergoing training, and the fact that complaints may roll in, which will likely require like a closed session review of the complaints. So there's gonna be some discretion, and I just ask that you bear with me with regard to that.
Okay, thank you. All right, well, with no further business before the commission, I hereby adjourn the commission meeting. The time is 9:36 p.m. The next meeting of the Police Oversight Commission is scheduled next week, March 14th, 2024, 5 p.m. Thank you, everybody.
Thank you.